Oh, Mr. Young, hello.
Doing well. Amethyst Garcia may show up here with a walker and get prosthetics and all sorts of
Okay.
stuff on it. So we're supposed to come back at 2 o'clock.
Hello. How's it going?
Very well.
Okay.
If I could just get everybody to do one thing or the other.
I feel your pain. Yeah, I know that.
Yeah, you know, if all the courts would do Zoom, I'm fine. If all the courts would do in person, I'm fine.
Let me just tell you, it's like herding cats.
Yeah. Well, when you have, 25 or so independent duchies, they do it the way they want.
Well, I still think there are COVID issues, so I have Zoom unless we're having a jury trial or we are receiving evidence or someone doesn't agree to Zoom.
Yeah.
And my understanding is there's supposed to be a new variant. And of course, I know that there is always probably going to be variants, but that doesn't excuse us for not being careful,
And the alternative argument is we have 75 cases a day
Mhm.
in 1.5 million people.
Mhm.
And that's probably less cases than you have a sexually transmitted disease, and people haven't stopped doing that. So
I don't know if you can compare the two, but all right, then we will see you at 2.
Yep, and I'm gonna try and get hold of her and tell her not to come. She probably hadn't gotten up yet, so.
Okay, all right, thank you. All right, everyone, just give me a moment. I'm just waiting for your attorneys to appear, and as soon as they appear, we'll start. Thank you, Deputy. Ruben Coronado, you need to pull off that hat. You need to find a place. You need to be dressed appropriately for court. If you want to continue to appear by Zoom, then you need to dress appropriately for court. And you need to take off that headdress.
He knows.
And everyone, just give me a moment. I'm waiting for your attorneys to log on.
So.
And then she called Sawyer secretary yesterday.
Yeah. Did you get the?
Mr. Snow?
Yes, ma'am.
Yes, I'll need you to come back at 2 p.m., okay?
Okay.
All right, thank you.
Thank you.
Mr. Carnata?
Good morning, ma'am.
Good morning. I'm going to need you to zoom back in at 2 p.m. We're going to start a jury trial, all right?
Thank you, ma'am.
You're welcome. And Mr. Munoz, who's your attorney? It's Michael Sawyer, correct?
Yes, ma'am, Mr.
All
J.
right, we're
Sawyer.
just waiting, Mr. Sawyer, okay? Thank you. Yes, Mr. Navy?
Good morning, Judge. I have Ruben Coronado set today.
I thought you all are coming in at 2.
I'm sorry?
I thought you all were coming in at 2 p.m. If not, can you do me a favor? Because I excused your client till 2. If you can call him back because he was on earlier, and then
Okay.
we'll take care of your matter now. If you can get him back on Zoom.
Okay, sounds good. I'll give him a call. Thank you, Judge.
All right, thank you. All right, Mr. Davy, Ruben Coronado, what is happening with Mr. Ruben Carbonaro?
Judge, on this case, we just like to set it for a jury trial.
All right, just give me a moment. Did you receive the issue from the DPS attorney?
I did, Judge. I spoke with him about that, and I spoke with my client about that, and taking all of that into consideration, this is the decision that my client would like to make.
All right, and have you had a chance to speak with the prosecutors though?
I'm sorry?
Did
Sorry.
you have a chance to speak with the prosecutors about the update you found on Mr. Coronado?
I have not, Judge. No, I can.
Okay, let me see if we have prosecutors on. I think they know that we're supposed to be starting at 2, so they'll be back at 2 p.m.
Okay.
What I'm gonna do is I'm gonna give you a jury trial date. But if you are able to log back in at 2 p.m. so you can speak with the state to see if everything is going to go as planned as a jury
Okay.
trial, or if they're gonna continue with the same offer, knowing what you now know.
Okay. Sounds good, Judge. I'll log back in at 2.
All right, so your client won't have to log back in at 2. You can call him if an agreement is reached, and then he can log in at that point. Will he be able to do that?
He should, Judge.
All right, so I'm going to set your jury trial though. It's going to be April 19th, but you'll need to come back on April 18th. That's the last chance to confirm.
Okay. Thank you, Judge.
You're welcome. You and your client are excused.
Thank you, Judge.
Thank you, Judge.
Thank you. Have a great day, Mr. Coronado.
You too. Take care, man.
All right, that's okay. Court is calling 2021 CR 3542, State of Texas versus Carlos Munoz. Can I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Michael J. Sawyer for the defense.
And are you Mr. Munoz? Mr. Munoz, can you unmute for me, please?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. The defendant is actually on Zoom and the defense attorney and state are present in the courtroom. Any objection to the sentencing taking place by Zoom? Defense,
Not for the defense.
state?
No, Your Honor.
Mr. Munoz, do you have any objection to being by Zoom as opposed to being in person in the courtroom?
No, Your Honor.
All right, Mr. Munoz, you entered a plea of no contest to count 1 on February 23rd, 2022. Count 2 and count 3 were waived without objection. According to your plea bargaining agreement, punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine. The state is opposing your application for community supervision or deferred adjudication. And there are several cases that are being taken in consideration, as well as an affirmative finding of family violence. The court had requested in this case that a TAP evaluation be completed. Have both parties had a chance to review the TAP evaluation, state,
Yes, Your Honor.
defense?
Yes, Your Honor.
And are both parties ready to proceed?
Yes, Your Honor.
Defense is.
All right, state, you're opposing the defendant's application.
We are. We don't have any witnesses to present, just argument, and we will have victim impact as well.
All right, defense, do you have any witnesses?
Your Honor, I first asked court to take judicial notice of the reports before the court from the TAP and the treatment synopsis, background, mental history, so on. I believe the court has them and has reviewed them.
Yes.
The only witness I'd call would be Mr. Munoz on his own behalf.
All right, Mr. Munoz, could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Could you state your name for the record, please?
Carlos Aleman Munoz Jr.
All right, defense.
Thank you. Carlos, do you know why we're here today?
Yes, sir.
Well, tell us what you think. Why do you think you're here today?
I'm here today to take responsibility for my actions on the people I may have hurt or have over drugs or drug abuse use. I'm ready to better myself. Oh, I'm sorry.
Didn't mean to overspeak. Go ahead, sir. Finish what you were saying.
I'm sorry, sir. I'm trying to better myself. I want to ask the judge and the attorneys, the state of Texas and the DAs and the prosecutors for a chance to better myself, because I know I can do this. It's just I feel like me being sober, and I look back and reflect on what I've done, that I know that I've hurt, a family that tried to be there for me, and I'll never get that back ever. I know that, but all I could do now is just ask for their forgiveness as well, and I'm asking for, for them to forgive me if they can, and so I can so I can start working on me. I know.
Well, let's stop. There's a few things we need to ask
Yes, sir.
you. First of all, tell us, how far did you go in the public school system?
I only went to 11th grade.
But you read and write the English language okay, do you not?
Enough to get by, yes, sir.
Enough to get by. You had no trouble understanding me today, do you?
No, sir.
Nor the judge. Should she ask you a question?
No, sir.
Can you tell Judge Boyd, how long have you been aware that you have mental problems?
Almost all my life. Ever since I was a kid, I was diagnosed with ADHD and a learning disability. But over the years, I learned to just kind of like by watching people and by learning how to, just by watching people, and I've learned how to talk better, and I've learned how to do things by observing others. I mean, I guess it led to to where I'm at now. I'm surprised I made it this far. But
You know, Judge Boyd, I mean to cut you off, go ahead.
no, go ahead, sir.
Can you tell Judge Boyd, what kind of drugs have you taken over the years to help your depression and mental problems?
I was using marijuana, and that was to cope with my ADHD. I was doing better in school until I got in trouble for it. I got in trouble in school. I had marijuana on campus. It was a class A misdemeanor at the time. I think I did a total of 11 days. I had 2 years probation. I completed it. But the only thing was, I guess I never went back to court for the judge to say, okay, you are done with it. It was just my probation officer said, you're done. I paid all my fines. I did all my classes, but I still had an MTR. That's why it still shows an MTR on it.
Carlos, I'm sorry.
No, go ahead, sir.
Sometimes I think you already stopped and you're still talking. I apologize.
Sorry, sir. It's this thing, I think.
Okay. Have you ever actually been in a mental hospital or a hospital, received any treatment for your mental problems?
Not that I remember. I mean, I remember I used to go to like little like clinics for like I guess I had to go for my mom used to take me a while back, a long time ago. I just, ever since I went to the street, I never tried to seek help. And then when I did try to seek help, I was rejected, turned down. They refused me, they denied me. So I just kind of just went towards the drugs, I guess. And then I just got stuck in that life and been there ever since.
So you've basically been a street person for a good part of your life. Is that a fair statement?
Yes, sir.
Can you tell Judge Boyd, where were you living when you met this family?
I was living at the Haven for Hope. And
Later?
yes, sir. Later, I returned. I got a job at McDonald's, and I was working at the McDonald's, and I found her attractive, and she, I guess, proceeded with me. And I didn't know at first. I didn't think she was really going to be into me, because I told her from the beginning. I said, I'm a loser. I don't think I have going for me is this job. I live at Him for Hope. I'm homeless. I have no car. I have no house. I have nothing to offer you. And I said, you still want me? And she's like, yeah. And I just like, I didn't know. I felt like, okay, if this woman's willing to give me her time, let me try to be a good dude.
Of course, is this how you came to meet this girl and meet her family?
Yes, sir. Yes, sir.
Later on, did you come to live with that family?
Yes, sir. At first I wasn't up for living there, but then she kind of like asked me, why don't you come live over here with us? And I told her, I said, no, like, because, like, I got things I'm going on here. But then, at first I was thinking like, yeah, maybe I should. And everybody was telling me at the place, like, hey, you're crazy for not.
Of course, we have to kind of keep this on track.
Yeah, yes, sir.
Now, during the time they were living with the victim and her family, they reached a point in time where, in fact, you left again and went to live somewhere else.
Yes, sir.
And where were you living?
Dallas, Texas. I went to go over there to go turn myself in, because I told her, I said it turned out that I had a warrant out for my arrest, and I said, man, it was just a matter of time before this warrant would catch up to me and we would be stuck with it. So I said, let me go take care of this. And I said, it might be 2 years I might be in there, but it wasn't. I actually got time served for it. When in that time I was with her, the husband was still like, he was, you could see he was upset that I was with her, but at the same time I was like, sir.
Carlos, I need to keep us, we need to go about the questions I am asking.
Yes, sir.
We can't reinvent the wheel in front of the judge today.
I'm sorry.
Returned back from Dallas. Did you take up your relationship with the victim again?
No, sir. I left Dallas. I did exactly what the judge asked me. She said, if I see you in here, she goes, I'm going to go ahead and agree to this time served deal. And I said, thank you, Your Honor. She goes, if you were to go back to that victim or to contact her, I will. If you come back to my courtroom, you will do a year in Dallas jail day for day. Do you understand me? And I said, yes, ma'am. And she
So,
goes, yes, sir. I
came
left.
back. And eventually you had a problem that led you being arrested, and that's why we're here today. Is that correct?
Yes, sir.
Led to that charge. Now, what Judge Boyd needs to know today, if she were to grant your application for community supervision, how can you assure the judge you're going to stay away from drugs? How can you assure the judge you'll try and get help for your mental problems? You have a dual problem. You've got a drug problem and you've got mental issues. You know that, right?
Yes, sir.
And you're asking the judge to give you probation. What are you going to tell the judge? How can you assure the judge you will do all the right things?
All I can say is that this is the first time I'm actually taking my life into seriously, and I've never been more serious in my life other than the time I left Dallas. All I would like to say is that if you grant me this, I will try to go. No, I will go to this place called I think it's called the Re-Entry Center. I was reading it on the kiosk. I'm not sure. They say they have like an inpatient thing where you can admit yourself in, and
I
help
was
me
going to
get.
ask you this. I know you're not discussed that issue. If the judge were to grant probation, for instance, the judge can impose any kind of program the judge sees fit, including inpatient. Whatever it takes. Can you look Judge Boyd in the eye today and say, Judge, I'll do every single thing you ask me to do. If you want to place me in treatment, are you willing to do that?
Yes, sir.
Is there anything else you want to tell Judge Boyd before we talk about?
Yes, sir. I was gonna ask her. There was somebody had told me something about the lifetime recovery. Is that a good place for you? Think I could be able to because everybody was telling me that they'll help you with a lot of stuff over there, and I could definitely use that kind of help. But I just like for the Miss Boyd to know, like, I'm sorry for the things that I did, and if I'm not sure, I see her name's up here, Miss Laura Rodriguez Mojica. I see that she's looked on Zoom. Just want to let them know that I would like them to know that I'm sorry.
Carlos, let me ask you this. You're looking at Zoom right now. Tell me, who is the judge? Can you see the judge on screen?
Yes, sir.
The person with a black robe on, right?
Yes, sir.
Okay, that is Judge Boyd. And that's who you've been addressing these comments to?
Yes, sir.
Carlos, thank you for your time. Your Honor, that's all I have right now. I'll pass the witness.
All right, thank you. Mr. Munoz, the court has had a chance to review the PSI report and review all the documents. And you previously had assaultive history. The court is going to deny your application. Would anyone like to speak towards the cap?
Judge, we would ask that you hit the cap in this case. As the court is aware, the defendant, well, for one, he's not here for a drug offense. He's previously been given an opportunity on drug offenses. He's here because he continuously likes to abuse women. And the court is aware that he was recently convicted as recently as 2016 in Dallas County. And then again in 2019 for the same offense, assault, family violence, and 6 violent offenses, including different victims, are being taken into consideration for the plea in this case. We're taking into consideration an assault family second, an ag assault deadly weapon, an assault family second, an assault family second, and a terroristic threat family household, and another assault family choking strangulation. This defendant continues to pose a danger to society, and he's not getting the message that this is not okay. So we ask that you max him out.
All right, defense.
Your Honor, I don't think anyone's beyond redemption. I really don't. He has a real serious problem with relationships with women. Understand that's evident from the convictions, from the arrest. One thing is quite clear, he's never really gotten the mental help he really needs. It's far easier to warehouse someone in prison than to put him in a situation where, at least in prison, you can get some help for your issues, especially mental issues, how you interact with people. Otherwise, you do your time in prison to get back out and start recreating the same behavior as before. I think he's asking courts, no matter where he goes, in his prison, there'll be some program to help him with his problems. That's all I have, Judge.
Mr. Munoz, the court can ask or request that you be placed in the therapeutic community. However, it won't increase the amount of time that I will sentence you to, but you will have to request it yourself. Just me requesting it is not going to get you into the program because I have no jurisdiction or authority to force you to do that. And sometimes even if you request it based upon whatever your offenses are, they may not accept you. But if you would like for the court to place in the order or my ruling, my judgment, that you be placed in the therapeutic community, or a request be made that you be placed in the therapeutic community, I can do that. And while you're at the prison, they will be able to address any mental health issues you have, and they will be able to address drug issues. So would you like the therapeutic community?
So what just happened right now? Like, am I,
You're being sentenced to prison.
this court, this is trial or something?
All right, so this is what the court is going to do. The court is going to sentence you to 10 years in the prison. There's a $1,500 fine, time and money to run concurrent. Take in consideration 2021 CR 3541, grand jury number 756871, 65270, 2021 CR 3543, 2021 CR 10252, 2021 CR 10253. There's an affirmative finding of family violence. Mr. Sawyer, I'm requesting for the therapeutic community, but Mr. Munoz, if you don't request it yourself, they most definitely will not put you there.
Judge, I will request my client find out. If he doesn't know how, I'll show him how to get it done, Your Honor.
All right, thank you, Mr. Sawyer.
Judge, thank you for your time.
Mr. Munoz, I'm showing you what's in title trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do
Yes,
not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Also, because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what the definition of a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, Mr. Munoz, we're gonna go off the record. Good luck to you, Mr. Munoz. It
Yeah,
seems like you should probably not be in relationships. What I'm gonna do, Mr. Sawyer, I'm gonna open up breakout rooms. My understanding there's victim impact.
Yes,
State if you could have your witness at a computer to sign in, and they'll be sent to a breakout room to do victim impact. And Mr. Sawyer, if you want to go into one of the breakout rooms with your client, if you'll go back in the back offices, they have the computer set up and you can talk to him as long as you wish.
I will do that.
All
Thank you,
right,
Judge.
thank you, Mr.
Appreciate
Sawyer.
it.
It's always a pleasure seeing you.
Always good to be here.
And
All right.
Judge, I'll get you those dismissals at some point today.
Okay, all right, thank you. So, Mr. Munoz, if you go to breakout room number 2,
I believe she's locked on the floor.
She's on those.
let me send her to breakout room number 2. And if someone could go to number 2 with them.
Is this here, this back?
Oh, no, it's in the back offices.
Wherever it is, just tell me where to go.
All right, thank you. And to the clerks, I'm sending you to breakout room number 2.
Okay, thank you.
And Miss Flora Rodriguez, if you could go to breakout room number 2, please. And we're going to go on the record in this case, and then we're going to bring in the jurors. So we're on the record in cause number 2019 CR 3013, state of Texas versus Jeremy ROTHENAY. Do I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Robert Mount for defendant, Your Honor.
And are you Mr. ROTHENAY?
Yes, ma'am.
All right, we were, just one moment. Let me send her to number 2. All right, we were here yesterday afternoon, and there was an issue with regards to the witness, the state's witness testifying about a statement from the complainant's brother. State, did you tender that statement or the notes that you took from your interview with the complainant's brother to the defense yesterday?
Judge, there was no statement taken, but we did tender the notes.
All right, and defense, my understanding, you've had a chance to review those?
I did, Your Honor.
And with regards to your request for a mistrial, Mr. Maurer?
Judge, as I informed the court yesterday, it's my intent to withdraw my request for mistrial if the state agrees not to call the child as a witness, since I was not given notice of their conversation with him. And if they're okay with that agreement, I'm fine. If not, I need to have my argument on a mistrial.
All right, and my understanding from the state, so the record can be clear, the witness that we're speaking about, what is the witness's name?
Elijah Strong.
All right, so state, do you have any intention of calling?
We do not. We would just ask that defense be instructed or agree not to say, well, the state could have called this person. I mean, I think it's.
Well,
fair
now
to
let's,
say that-
no, let's deal with where we are now. Where we are now is the defense is saying they will withdraw their request for a mistrial if the state is not planning on calling the complainant's brother as a witness. So is the state calling the complainant's brother as a witness, yes or no?
No, we're not.
All right, defense, are you withdrawing your request for a mistrial?
On this issue, yes.
All right, then let's, the court then will note for the record that the defendant's request for a mistrial then has been withdrawn by defense counsel. All right, let's
And
move.
Judge, with the stipulation that the state not attempt to call the child as a witness, correct?
The state has stated they are not calling
Okay.
the complainant's brother. Let's bring the jury in.
All right, so the jury, should I get the witness?
Yes, please. Thank you. All right, everyone, please be seated. And do you need to have your leg lifted or anything? All right, just let us know when you need to have it lifted and we'll make that happen, okay? All right, everyone, thank you all. I'm sorry for us starting late. And the reason why we started late today has absolutely nothing to do with this case. It had to do with another matter that we were continuing from yesterday. All right, you've been previously sworn in. You're still under oath. Do you understand?
Yes, ma'am.
All right, and I believe defense, it was your cross.
I thank you, Judge. I think I lost track. I can't really remember where we left off yesterday, but I just had a few more questions for you. You and Jeremy, I guess, were together for a sum total of what, about 6 months?
Roughly, yes.
Okay, and he had been in the house and moved in the house with you for about a month. Is that correct?
Yes.
Before he moved in, or before y'all were in a relationship, who would watch your kids when you would go out, either at work or after hours, when you go out with your friends to do things?
My parents.
Okay.
And for the majority of the time that I was with him as well. It was
Okay.
my parents.
And did the frequency of you going out change once you and Jeremy got together? Did y'all go out together, or did you go out at different times? Y'all had a different work schedule, right?
Yeah, I worked in the evenings. but I don't think we were going out very often. But yeah, sometimes we would go out together.
Okay, what was your work schedule?
Evenings, like 4 to anywhere between 10 or 11.
So before Jeremy was in the house, your parents would watch the kids when you were at work?
Yes,
And then after you and Jeremy got together, after Jeremy moved in the house, he assumed the duty of watching the kids most of the time?
no.
Okay,
My mother still watched them most of the time. He would watch them for short periods of time, but if it was like a whole shift, my mom would still go to the house, drop in. But he was never with the kids on a regular basis for long periods of time.
did any of your children express any sort of concern about Jeremy moving in the house?
I don't think any more than like the usual. My son wasn't really fond of him. So he kind of complained about it. But it wasn't like an ordinary amount, you know?
What was your kids' relationship with their father? Was there a visitation or how did that work?
No, they had not seen their father in probably 2 or 3 years, when I started seeing Jeremy.
Did they ever, did they speak to him? Did they ever talk to him?
Yes, yeah, they would talk to him on the phone and stuff like that.
So did he surrender his rights? Was there just no custody agreement? Why weren't your kids seeing their father?
He wasn't in a good place. There was no like custody or court agreements or anything like that. He was just in a good, or I was in a good place and he wasn't.
Did you and Angelina ever have a conversation where she expressed concern about Jeremy getting in the way of her being able to see her dad?
No,
There was never any conversation where she had talked to her dad on the phone, and then she had come to you about wanting to see her dad and Jeremy being in the way?
no,
Never happened?
no.
Okay. When you wrote out your, well, let me take it back. You went down to meet with, I guess, either a detective or somebody, and they had you write out a statement, right?
Yes, child safe.
And then you also gave a statement out at the scene, right? When the police got there.
Mhm.
Did you give any other statements to anybody or write anything else out?
I don't believe I ever did another written statement.
Did you ever do another oral statement to anybody?
I don't think so, no.
And when you were testifying yesterday, you said that you had told Jeremy to either leave or stay here and talk to the police. Is that what you said?
Yeah, I mean, I told him that I was calling the cops, but he had to get out of the house regardless. I told him he can go outside and like wait for the cops to get there or, you know, just leave. But regardless, I wanted him out of the house, period.
Okay, because if you recall, when you gave your statement out the scene that night to the patrolman, you never said anything about telling me he could wait outside. You told the patrolman you kicked him out of the house. You got your car key and house key and told him to leave. Do you recall saying that?
Mhm.
Right?
Yeah,
Okay, and then when you gave your written statement, your handwritten statement, you said the same thing. You kicked him out of the house, told him to leave. Right?
mhm.
Is that yes?
Yes, but I also can't control what he does once he's out of my house.
I understand that. But at no time did you ever, either in your statement to the patrolman or your handwritten statement, say anything about telling him, oh, he could wait outside for the officer to get there and speak to him? You never said that to anybody.
Because I wasn't really worried about that. I was just worried about getting him out of my home and away from my children.
No, I understand that, which is why you said you kicked him out of the house. What I'm trying to clarify is your statement yesterday was, and I told him he could wait outside until the police got there and talked to him. And you never said that to anybody before yesterday.
I don't know.
Well, it's not,
I'm not sure.
did you met with the DA's office a couple times, right?
I met with them once in person. Before that, I was only in contact with Marina throughout the past 3-4 years. Just randomly, she would update me on, court dates, stuff like that.
Okay. So what evidence, statements, reports, videos did you review prior to testifying?
Did I review?
Yeah.
Zero,
Nothing.
nothing.
Okay. So would you agree with me that your recollection of events was probably better at the 4 years ago than it is either yesterday or today?
Yeah,
Okay.
definitely.
All right.
As far as like the small, tiny details,
Okay.
but not what happened.
Okay. So let me go back to what we were talking about. So at the scene, when the officer arrived there, all you said was you got your house key, your car key, and you kicked him out of the house, right?
Yes.
Okay, you never said anything about, I told him he could wait outside and talk to you. You never said that to the patrolman,
Can I object? This is
No.
a past answer, Judge.
All right, that'll be overruled.
right? So what, you can go ahead and answer the question. You said, I don't believe so, right?
I don't believe so. I don't know.
Okay, well, you didn't. So, I mean, you said you don't believe so, but in fact, you did not, because there was a video.
I just don't remember that being an important detail.
Okay.
So I'm not sure.
But I mean, the event had just happened, right? I mean, you just kicked him out of the house, right?
4 years ago, yes.
Yeah. But at the time the patrolman came to your house,
Uh-huh.
you had just had this whole blow up and kick Jeremy out of the house, right?
Yes.
And at no time did you mention in that statement, I told him to wait and talk to you, or I told him he could wait and talk to you and explain things, right?
Yeah, no, probably not.
And then the same thing when you gave your statement or gave your handwritten statement to, I guess, Detective Stokel, whoever you gave it to, same thing. You just said, I kicked him out of the house. That's it.
Yes.
Okay. I passed it.
State.
Just a few things, Christina. So I know we talked earlier, like way earlier, as in yesterday morning, about where you were living at the time this occurred. And just for the sake of having it on the record, was this in Bear County, Texas?
Yes.
How long were you and your ex, the father of the children, together?
I want to say about 7 years.
Okay. And when did you guys split up?
We split up, oh gosh, probably, like I said, about 2014 when I originally moved here. And then we tried to make it work a couple of times throughout like 2015, 2016. But it was probably towards, I think it was 2016 was the last time, we tried to work anything out, and then after that, that's when the kids hadn't seen him for a while.
Okay. And was Jeremy the first person you dated after splitting with their father?
There was one other person that I dated for maybe a year and a half.
Had the kids met him?
Yes.
Okay, so Jeremy was not the first boyfriend to be introduced.
No.
ask the witness, Judge.
So the kids had seen you and your ex, I guess, try a couple times to get back together, right?
Yes.
Okay. Do y'all live together in the same house?
No, he had his own apartment situation for a little bit. But it was always very short periods of time that he was here. I think at one point he stayed with us for like a week or two, and then he went back to New Mexico where he lives. And then he came back like maybe almost a year later. We tried again. That's when he had his apartment. And that was maybe for like 4 or 5 month period.
And that was the 2016?
Yeah, I believe so.
Okay. And that,
I was,
hold on, let me, okay,
Okay.
it's gonna be easier if we do a question and answer, okay?
okay.
So, and when y'all were together, I guess particularly for that 5 month period, it probably made the kids happy to see the two of y'all together, right? It felt like y'all were like a family again,
Yes.
right? And I'm sure as far as you're concerned, maybe you started to feel like it wasn't gonna work, but the kids like that part, right? Y'all being together.
Of course.
And were the kids upset either at you or him when that 5 or 6 month period ended, that y'all were breaking up again?
They weren't upset with me.
Okay, well, maybe upset with
They
him,
were
right?
pretty understanding, yeah.
Okay. And so after that breakup of the 5 or 6 month period, the kids would still talk to their dad quite a bit on the phone.
Yes.
And would they ever express desire to you for y'all to try again to get back together?
No,
Nobody ever did?
no.
Okay. I'm no further question.
State,
Nothing further from the state.
all right, is this witness excused or subject for recall?
Yes, from the state, Judge.
All right, thank you, you're excused.
Thank you.
State, call your next witness.
State calls Eric Mata.
All right, you take a seat right here, please. You can raise your right hand for me. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? I do. All right, please have a seat, and if you could state your name for the record.
Eric Mata.
All right, state.
Good morning, Eric.
Morning.
Can you please briefly tell the jury what you do?
Sure, I am a forensic engineer at the local child advocacy center here in Bexar.
And what is Child Safe?
So we are a child advocacy center. We specialize in providing services to abused children and their non-offending family members.
What kinds of services?
We offer forensic interviewing for our law enforcement partners as well as our CPS partners, and we offer counseling services for the victims and their families.
What kind of education and training do you have to work at Child Safe?
So I graduated in 2016 with my bachelor's in community health, public health, and I had to go through about 40 hours of specific training to become a forensic interviewer. And I also have a certificate or certificate of a forensic interviewer.
How did you start your career at Child Safe?
So actually, I started as an intern back in 2016 on my final semester at college. I interned there at Child Safe. It was on a list, and that's the one I chose. I did interning for about 5 to 6 months, and after I interned, I was hired full-time as a family advocate.
What's a family advocate?
Essentially someone who provides the family with resources such as counseling as well as community resources.
When did you start conducting forensic interviews?
I became a forensic interviewer in December of 2017.
Since December 2017, approximately how many forensic interviews have you conducted?
Anywhere between 1,500 to 1,800, somewhere around there.
Okay. And when you conduct these forensic interviews, are they with adults or children or both?
It can be both.
And what kinds of things do you interview for? Is it all sex abuse or is it multiple types of abuse?
No, it could be anything from sexual abuse to physical abuse, neglect, sexual exploitation.
So is ChildSafe like a law enforcement agency or something different?
No, we're a neutral party. We are not law enforcement. We're not CPS. Essentially, we're just here to provide services to the families as well as to the investigators.
What's the purpose of a forensic interview?
Essentially, it's just a fact-finding interview. A lot of people have a misconception that it's an interrogation. It's really not that. Really, our main purpose is to provide a service to law enforcement or to CPS, and that we gather information, and then the investigators will then decide what to do with that information.
How is like the structure of the forensic interview? What do you do to prepare to conduct a forensic interview?
Sure. So whenever the family arrives at ChildSafe, they are referred to us either through CPS or through law enforcement, whoever the investigative party is. Once they are referred to us, then they will come to our building along with the investigators. Once at our building, we introduce ourselves, let them know what it is that they're doing here. Myself as a forensic interviewer, as well as a family support specialist, will say hello. We'll bring them back. We'll explain to the parents the purpose of their appointment today, as well as to the children. And once we do that, we move forward with the forensic interview.
Okay. Is there any structure to the forensic interview, or does it kind of depend on the age and the case?
Yeah, so there's a structure. It's called the semi-structured narrative process. So essentially, we just kind of follow a script whenever we're interviewing children. So essentially, every interview is the same in that we kind of follow the same script with every child. We start off by building rapport with them, making sure that they're comfortable in the room with us and answering all our questions. We have them talk about really whatever they want to talk about, just to get them comfortable in the room with me. Once we do that, then I will explain to them the rules that we have in the room, such as, correct me if I say something wrong. If you don't know the answer to one of our questions, just tell me that you don't know, then we can guesses. And once we do that, I will then have them tell me what the difference is between the truth and a lie. Once they can define the truth and the lie, then I have them promise someone to talk about the truth. And then that's when we talk about why they're here for the forensic interview.
Okay. What's kind of the structure of the questions that you ask them?
So the questions that we ask are open-ended, non-leading, meaning that we give the space for the child to tell us their side of whatever happened from their perspective without us really influencing what it is that they say.
Okay. So the purpose of this, is just kind of gathering questions or gathering answers, correct?
Investigative information.
Yes. Are you there to look for, deception or anything like that?
Not specifically. I mean, no.
Okay. So it's just a neutral, basic setting.
Right.
Okay. In your training and experience, what is an outcry? Well, the jury's heard this all week. What is an outcry?
So whenever a child makes an allegation, or really anybody makes an allegation of any sort of abuse, whenever they outcry to an adult is whenever, I guess that would be considered an outcry, whenever they tell a trusted adult what is going on.
Okay. So an outcry witness would be the first adult to tell.
That's correct.
Okay. Have you ever been, I know you're not in this one, but have you ever been an outcry witness before?
Yes.
Okay. Now in these cases, once you're told you're assigned kind of or referred this case, do you know what the situation is ahead of time, or do you go in completely blind?
No, most of the time we will staff with the investigators prior to the forensic interview, and they'll inform us on all the details that's going on.
Okay. At any time, is the investigator able to, tell you if you've missed anything?
Yeah, that's why they're there.
Okay. So where are the investigators or the CPS workers whenever you're conducting these interviews?
So the investigators, we have a long hall, and on one side of the hall is the interview rooms, and on the other side of the hall is the observation rooms. So I'll be on one side of the hall with the victim in one room, and in a separate room on the other side of the hall are the investigators, and they're observing through a computer monitor live at the time.
Okay, at what point in the interview are they able to tell you if there's anything else they want you to ask?
So I will conduct my interview as planned, and whenever I feel like I've gathered most of the information that I can, then I'll take the opportunity to walk out of the interview room and meet with the investigators in the observation room. And then at that point, they can tell me if I missed anything or if they have any additional questions.
So while you're conducting these interviews with children, what types of things are you looking for? Like what kinds of things are you observing? Like their demeanor?
Yeah, sure.
Judge, I'm gonna object to leading the witness.
Sustain.
Yeah, I do.
Excuse me.
Yes, I'm sorry.
Whenever I sustain an objection, that means that you're not to answer the question.
Okay.
All right. And if you have any questions over when an objection is made and I give my ruling, just ask me.
Yes, ma'am.
All right, thank you. All right, that objection is sustained.
Yes, Judge. So when you're conducting these interviews, what sort of details are you looking for while you're talking to the children?
So really, we ideally we want to see consistency with their outcries. We want to we do look at their demeanor, and we do look at really just a variety of things.
Do you look for any signs of coaching or that anything's been made up?
We do typically ask about coaching as well.
What do you look for when you're looking for signs of lying or coaching?
Typically, we'll talk to the kids about has someone talk to them about what they should be talking about today? Has someone told them what not to talk about today? Are they afraid of anything happening if they do talk and open up during the interview? And these are some signs of coaching.
Okay. Have you ever had children show?
Judge, I'm gonna object to relevance as far as him testifying about other cases. It's not relevant to this case.
All right, and let me hear the full question, then the court will make its ruling.
Have you ever had children show signs of coaching in these interviews?
Judge, I'm gonna object again about relevance.
All right, that'll be overruled.
You can answer the question.
Can you repeat the question, please?
Have you ever had children show signs of being coached in these types of interviews?
Yes.
You said that you've interviewed over 1,500 people. During this time, with all of these children interviewed, do children have perfect memories?
No, I don't think anybody does.
Okay. If someone doesn't have a perfect memory, does that mean they weren't abused?
No.
Do kids always give a complete outcry about what happened to them?
No.
What kind of elaborate on what you mean by that?
So there are many different stages of disclosure. There's many reasons why a child will not make.
Judge, I'm gonna object to non-responsive.
Sustained.
What are some reasons why a child would not give a complete outcry?
Oftentimes, if a child doesn't make a complete outcry, it can be for a multitude of reasons. Maybe the suspect is still living in the home with them and they have to go back home after the interview is done. Sometimes the suspect or the alleged perpetrator is the primary breadwinner in the family and the child knows this. And they don't want to put an additional strain on the family if for whatever reason the suspect will no longer be allowed to live with them. And those are just a few of the reasons why.
Do kids always react the same way to abuse?
No.
What types of reactions have you seen while conducting these interviews?
That's kind of a tough question. I don't think there is any normal reaction. It could be any range. It can start from, having zero emotions, completely, stone face, just matter of fact, and it can go all the way to the other spectrum where they are extremely, uncontrollable in their emotions and they're crying, and really, at that point, we can't move forward. It can go either end or anywhere in between.
So going to the incident that we're here to talk about, are you familiar with a girl by the name of Angelina Straub?
Yes,
Did you conduct a forensic interview with her?
yes,
And just to be specific, were you the outcry witness?
no,
Do you know who the outcry witness was or who the first adult she told was?
I believe it was some other.
Okay. And in preparation for testifying today, did you review the forensic interview?
Yes,
When you talked to her, was she able to provide sensory details?
yes.
What was her demeanor like during the interview?
For lack of a better term, she seemed fine. She was very matter of fact, and she, presented normally, I would say.
Okay. And like you said earlier, there's no universal way for.
Judge, I'm gonna object to leading the witness.
Sustained.
Moving on. When you interviewed her, did you screen her for signs of being coached?
Yes.
Did you detect any signs of her being coached?
No,
Did she give a consistent statement?
she did.
And at any time, did you step out and speak to the detective?
Yes.
Did you receive any further direction from him, or was he happy with how the interview had gone?
I didn't receive any further directions.
Ask the witness, Judge.
Defense.
Mr. Mata, my name is Robert Mauer. I'm going to ask you some questions. Please let me know if I confuse you with my questions, which apparently I've been doing lately, or if I'm speaking too quickly, and I'll try to rephrase or slow down. So did you, what materials did you review prior to testifying here today?
I did observe the forensic interview. Again, it's been a few years since I conducted the interview, so I did watch the interview again.
Okay, and when you were here yesterday, you had a folder with you with some documents with you.
Correct.
Do you have it with you today?
Yes.
Okay, what documents do you have with you?
I have my subpoena, I have my CD, and I also have a report that forensic interviewers write after the forensic interview is conducted.
Is it a handwritten report?
No, it's typed out.
Okay. You have it with you?
Not on me, but it is here.
Okay, where?
I believe the victim advocate has it at the moment.
So you said you've done 1,500 of these interviews, right?
Correct.
Okay, so tell me what are the protocols when you screen somebody for coaching? Okay, tell me what the screening process is. I mean, is there a series of questions you ask to determine whether or not somebody's being coached?
Yes.
Okay, they are what?
Just as I mentioned before, it's usually the three questions that I said. It's has someone told you what to talk about today? Has someone told you what not to say while you're here today? And are you afraid of anything happening if you go back home today after talking today?
And that's it.
Yeah.
So if the right answer to those three questions to you, they either are being coached or aren't being coached. Right? Correct?
Yes.
Okay. What about if they lie?
So as a forensic interviewer, it's not within my responsibility to determine if a child is lying or not. My responsibility is just to gather the facts.
Okay, but well, you just when the state asked you this question, you said you did a screening process and you determined that this girl wasn't being coached, right?
She said that she wasn't.
Okay, so you're not saying that, right? You have no idea about whether or not she was coached, right?
Correct.
Okay, and your screening process, would you agree with me, is pretty cursory, right? I mean, you ask three questions to determine whether or not somebody's being coached or not being coached, and that's it.
Well, I mean, it doesn't just limit itself to those 3 questions. There are other signs if children are being coached or not.
Like,
Inconsistent statements. I can't think of really any other at the top of my head at the moment, but you know, there's a multitude of ways to determine or to notice that a child is not being truthful.
okay, well, you just told us you thought this child wasn't being coached. So tell me what these multitude of other ways are.
So as I mentioned, the child making an outcry that is inconsistent probably is one of the biggest signs. I cannot think of any other at the top of my head.
What, but you just talked to the state and the state asked you all these questions about a child's imperfect memory, right? So even being inconsistent might not be a sign of being coached, right?
That's right.
Okay, so can you and I make the agreement that the questions and the screening process you have don't really determine whether or not somebody's being coached, right? Is that a judgment call you make?
I'm not sure I understand the question.
Okay, so if you think somebody's being coached, say you have a detective outside, right? Do you go out and say, hey, I think this child's being coached?
Not typically, no.
Okay. If you think a child is being coached, do you take that report to a supervisor and say, hey, I think this child is being coached?
Not typically, no.
Okay. So, and you talked about the inconsistent statement, right? So what did you review prior to this forensic interview?
As I mentioned before, just the forensic interview itself.
Okay, but you said, you didn't review, you said you look for inconsistent statements as a sign of somebody being coached, right?
Yes.
Okay. So in order to determine whether somebody's statement is inconsistent, wouldn't you have to know what the previous statement was?
It could all happen within the interview.
Okay. And did you talk to Detective Stokel prior to conducting the interview?
Yes.
Okay. And did Detective Stokel ever mention that, in fact, the child had given a statement before?
Actually, I'd like to take that back. I'm not 100% sure if I spoke with Detective Stokel because I know CPS was also involved. And off the top of my memory, I know that one of the parties or both had to be there. I don't know if they were both there.
Okay. Were you ever made aware by Detective Stokel or anybody from SAPD that the child had given a previous videotape statement?
Not to my recollection.
Okay. You talked about consistency in demeanor, right? And then the state asked you about perfect memory or imperfect memory of a child, right? But in all this, can we come to the agreement that your job is to conduct an interview, right?
Correct.
And that's all your job is, right? You conduct the interview, you write a report, you may meet with the detectives and talk about questions to ask. Is that correct?
That's most of what my responsibilities are.
But at the end of the day, you have no idea whether or not the allegations being made are true, correct?
That is not my decision or my assumption to make. That's for the investigators.
Okay. So is that a yes?
I don't know how to answer that question.
Well, my question was, you have no idea whether or not the allegations being made are true. If you're not there, you take a report and that's it. But you have no personal idea whether or not the allegations are true, correct?
Everybody can have their opinions, but just because I have my opinion, that doesn't mean that it's gonna weigh any value.
That wasn't my question. My question was, and Judge had asked the witness be ordered to answer the question. You have no personal knowledge whether or not any allegations that are made to you in any interview are true, correct?
That's not entirely true.
Okay, well, wouldn't you have to be a witness or a participant in an act in order to determine whether or not it's true?
Not really.
Unless it's videotaped?
No, sir. Sometimes prior to the forensic interview, a victim has already seen the doctor at Center for Miracles here in San Antonio for.
Okay, well, let's talk about that. That didn't happen in this case, right?
No.
Okay, so what you,
Actually, I don't know if she went to Center for Miracles.
well, you staff a case prior to doing the interview, right? Did you
Yes.
say that?
Yes,
And who participates in the staffing?
the investigators as well as the family advocates as well as forensic interviewers.
Okay, so a whole bunch of people there, right? And you talk about background and how we got here, right? And then they talk to you about what you need to find out about, right? Is that correct?
Yes,
Okay, so you're aware, right, that there was no medical evaluation or anything else at Center for Miracles, right? That was done on the complainant on this case.
I would have to look at my notes. I don't know that for a fact.
Okay. Yeah,
Not on me.
so let's see whether or not there was a-
On here, it mentions that there was not a previous medical evaluation.
Okay. So what you had was, you got, you did the forensic interview, and then you said you do recall Detective Stokel, I think Stokel or Stakel, having some questions for you, some follow-up questions you were supposed to ask, is that correct?
No, again, I would have to look at that paper again to know who was present. I don't know if it was actually.
But somebody may have asked you, did you recall somebody may have asked you to ask any more questions or no?
I don't believe so.
And that's your involvement in the process from there, right? Other than coming here to testify.
Right.
Okay. I pass the witness.
See,
Just a few, Judge. In talking about, whether something's true or not, is it in your job as part of your duties to form an opinion as to whether or not something's true or not?
No.
Okay, but that doesn't stop you from forming an opinion, correct?
Okay.
Okay. And in your experience, have you interviewed other children who have been victims of indecency by contact, where they've just been touched over the clothes?
Yes.
And typically, in your experience, is there a medical evaluation in those types of cases?
No.
Pass the witness.
I have nothing further.
all right, is this witness excused?
Yes, Your Honor.
All right, thank you.
Thank you.
State, call your next witness.
State will rest at this time.
All right, ladies and gentlemen, we're going to take a short break. If I can have you all back at 11:25. That'll give each of you some chance to take a break, and then we'll come back. Remember, you've heard some evidence in this case, but you're not allowed to discuss with each other what you heard. I'll give you instructions on when you're allowed to deliberate. All right, everyone, please rise.
Judge, we do have. Both parties had a chance to review it.
I did have no objection.
We have, Your Honor, no objection.
Are you ready to proceed?
We had one request. We just asked that. The state could have called it out. I think that's.
Not one. I absolutely intend for the state to follow the state and read the witness. I would do my objection to their violation of discovery. But the state did happen. They could have had the witness, and they did not. It's my client's due process right to argue that. And since in fact, what we had to do was not do any fault of our own.
Again, Judge, I think you have to. If you want to go and take that. I heard that's what it said. Is that you didn't call?
Everyone can make their arguments and if there's an objection that people have at the time of arguments, then people can make their objections and make a ruling.
Okay.
Excuse me. All right, state you've rested. Defense, do you rest?
You rested.
State, do you close?
We close, Your Honor.
Defense closed.
All right, ladies and gentlemen, I'm going to read to you what's called the charge for court. You'll be given a copy of this charge when you go back to deliberate. And it states, charge of the court, members of the jury, the defendant, Jeremy Ray Rothenay, stands charged in the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 28th day of July 2018 in Bexar County, Texas. To this offense, the defendant has pleaded not guilty. Number one, our law provides that a person commits the offense of indecency with a child by sexual contact if with a child younger than 17 years of age, whether the child is of the same or opposite sex, and regardless of whether the person knows the age of the child at the time of the offense, the person engages in sexual contact with the child or causes the child to engage in sexual contact. Number two, child means a person younger than 17 years of age. Sexual contact means any touching by a person, including touching through clothing, of any part of the genitals of a child, if committed with the intent to arouse or gratify the sexual desire of any person. Three, a person acts intentionally or with intent with respect to the nature of his conduct or to the result, or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. Four, now if you unanimously find from the evidence beyond a reasonable doubt that on or about the 28th day of July 2018 in Bexar County, Texas, the defendant Jeremy Ray Rothenay did intentionally or knowingly engage in sexual contact with Angelina Straub, a female child younger than 17 years, by touching part of the genitals of Angelina Straub with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of indecency with a child by sexual contact as charged in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty. On or about means that the law does not require the state to prove the exact date the alleged offense was committed. You are instructed that the time of the alleged offense mentioned must be some date anterior to the presentment of the indictment. The indictment in this case was presented on March 21st, 2019. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. Written or recorded statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can only send statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After you have retired to your jury room, you should select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify your verdict by signing the same as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your questions to the court in writing. If you want to communicate with the court, notify the bailiff. Any communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Board, Judge of the 187th District Court. Verdict forms are attached. State, are you ready to proceed?
Yes, Judge. May we adjust the monitors first?
Yes.
We have procedure on it?
Yes.
Thank you, Judge. Christina Bigler trusted Jeremy ROTHENAY with those 3 children. As you saw her testify yesterday and today, you know she regrets that. And you know she feels pain from that decision to trust him with those 3 little children. Our case here today is solely about the incident of July 28th, 2018. These were the elements Michelle and I had to prove to you, that on July 28th, 2018, the defendant, Jeremy ROTHENAY, intentionally and knowingly engaged in sexual contact with Angie, a child who was under 17, by touching part of her genitals with the intent to arouse or gratify the sexual desires of any person. We showed that to you. We all talked about the what witness rule, and that all you have to do is believe that one witness, the one person that it happened to. And Angie unequivocally told you that this happened to her, and she experienced it, and she felt the pain and the fear from it. Now, I want to draw your attention to the jury charge. It's a big chunk of words that you just had read to you, but this goes back with you. This is kind of your reference. You look at this for any questions about the law and any definitions, and including in that talks about what does not go back there. So first, let's talk about what evidence you consider. Testimony is evidence. You consider Angie's testimony, Christina's, Detective Stokel's, and Eric Montes. You think about what they told you, and you decide what their credibility is. Do I believe them? Yes or no? You also will get to take the photos back of the kids, so you can see what Angie looked like back then. She wasn't always a 14-year-old that looks like she's 17. She's grown up a lot in 4 years because a lot has happened. Time has passed. You also will get to take those tests. That initial outcry, moments after it happened, her frantic text to her mother, urging her to come back because Jeremy is touching her. You will get to take those back. Now, what is not in evidence are things that were referred to a lot. Police reports, any prior statements. These don't go back to you because what you are here to judge and base your opinions on is what came from the stand, what was testified to. If it was as simple as just playing a bunch of old videos, we would. But you are here to judge what was testified to today. So nothing that wasn't admitted goes back. Any comments made by us or any comments made by Mr. Maurer, you don't consider them. You just consider what was coming from the stand and just anything else not admitted. We talked briefly in jury selection about how do you judge credibility, and just think about the basics, the demeanor on the stand, if there was any motive shown to lie, what they said, if anything backs up other stories, and their body language on the stand. Think about how tearful both women became having to relive this night all over again. Now, as we talked about in jury selection, there is no definition of beyond a reasonable doubt. It is up to each of you, but you can look and remember that you would read that even if there's pieces missing from this puzzle, you know what it is. You know what happened. Ask yourself, well, first,
not beyond all doubt. It's not 100%. Just because a possible explanation doesn't mean it's reasonable. Use your common sense when discussing this with each other and ask yourself, do I have a doubt? Is it a reasonable doubt? But most importantly, is my doubt about what Ali and Michelle had to prove? And if the answer is no, then your verdict is guilty.
All right, defense.
Support. Ladies and gentlemen, I first want to thank y'all for being here. I know these aren't, jury duty is not fun for anybody. And I think everyone wants to be on some sort of fun and exciting case. These never are, but this is an important duty. And I want y'all to think about when we were doing board hour, we talked about things, right? Beyond a reasonable doubt, credibility, why people lie. So this entire case comes down to whether or not you believe Angie. That's it. There's no physical evidence. There's no corroboration, nothing. That's it. It's all about credibility. Now, I think the time I began to realize that there was an issue about Angie lying was when this new allegation came out. Right? Here we are 4 years later, and we have this brand new allegation. Well, the week before, he had come into my room and locked the door. And he grabbed my breast. And my mom knocked on the door because the door was locked. And he walked out the door and talked to my mom. What did the mom say? It never happened. Remember what I asked her? I said, if you're a mom and you find your boyfriend in a locked room with your daughter, somebody's dead, right? I mean, she said that didn't happen because she would remember that any mom would have, right? Your alarm bells would go off. Okay.
And I'm just going to object that that's a misstatement of the testimony.
All right, ladies and gentlemen of the jury, you will remember the evidence as it was presented to you.
You remember what you heard, right? So at that point in time, I think we've established that Angie lied on the stand. Now the state's going to try to say, well, yeah, a child's imperfect memory. This is not a child's imperfect memory. This is 4 years later, not like a fudgy deal or something. This is a brand new specific allegation that the mom said did not happen. And I think the key to this was the entire point about saying he walked out the door and talked to my mom. Right? So I think that's the most important thing. It all comes down to credibility, right? You know, the mom got on the stand and talked about, you know, the relationship with the ex-husband and things like that. But at the end of the day, the only three people in that room were Angie, her brother, and Jeremy ROTHENAY, right? That's it. So nobody in 4 years had talked to Elijah. Right? State finally didn't call.
Your Honor, I'm going to object for the reasons previously discussed.
All right, that'll be overruled.
So the only person who could allegedly corroborate what happened in that room never testified. And let's think about the investigative work that was done on this case. And it kind of bothers me on a case of this magnitude when people don't do their job. Okay. I was disturbed when the detective said he did not even realize that SAPD had body camera videos in 2018. I guess if he knew that, he might have reviewed the video. And the thing that bothers me is they talk about consistency in statements. Well, how do they know their consistency in statements unless they see the first statement to see whether or not the ones after that are consistent? Okay. Pretty important mistake to make. The other things, I guess Eric Mata testified about his job. And I found it interesting, the state asked him about whether or not he had been an outcry, which is an indication he had had some sort of assaultive history, right? Which is, I'm sure, why they asked him that, which may color his viewpoint.
Your Honor, objection, that was not the question asked.
That, Judge, that was specifically the question, whether or not he was in fact an
Judge,
outcry.
the question
one-
was. if he
excuse
was an
me.
outcry.
Yes. So ladies and gentlemen of the jury, you heard the evidence and you remember the evidence as you heard it.
So he talked about how, they do these interviews, he meets with law enforcement, they look at consistency, but yet again, he hadn't seen the prior statement either to determine whether or not, how can you determine if it's consistent if you haven't seen the prior statements? I think they try to indicate that he was an expert in coaching or determine whether or not somebody's being coached by asking apparently 3 questions. And I guess you assume people answer truthfully when you ask them those questions, because if you're being coached, you wouldn't lie on those answers. It just doesn't make a lot of sense to me. But I think all of that is like stuff floating around the outskirts of this entire case. The entire case comes down to Angie's testimony. Do you believe it or not? Okay. So we know she lied to us. Her mom told us she lied to us on the stand.
Your Honor, objection, that was not the testimony in this case.
Ladies and gentlemen of the jury, you remember the testimony as you heard it.
The mom told you that this new allegation that Angie brought up on the stand that happened the week before, the mom said that did not happen. Period. There was no equivocating. She wasn't being wishy-washy. She said, no, that never happened at all. Okay. So you can call it a mistruth. In my day, we call it a lie, right? You can't call it a child's imperfect memory when the entire allegation for 4 years has been one time, and all of a sudden something else comes up on the witness stand. Okay, so we've established the fact that Angie is not truthful. So on a case where everything comes down to credibility, where there's no other witnesses, there's no physical evidence, there's no video evidence, there was nothing else except her testimony. You cannot do anything but agree the state hasn't proven this case without a reasonable doubt or any doubt. Cases like this terrify me, because I think about what can happen in a situation where law enforcement rushes to judgment, doesn't do their job, and that's where y'all step in, right? Y'all, it's a tough decision for y'all to make. You have to go back and we've talked about your duty as jurors and what you're supposed to do. But at the end of the day, it's going to come down to 12 of you back in the room deciding whether or not the state has met their burden on this case. Okay. You agreed that the state had to meet the burden beyond a reasonable doubt. You agreed that if the defendant testified, you wouldn't hold it against him or consider it at all. Right? And we all talked about that. So what I'm going to ask you to do is remember everything you heard on the stand, what you didn't hear from the state as far as witnesses they didn't put on who could have corroborated this case, and find Jeremy ROTHENAY not guilty, because he is.
State.
Thank you, Your Honor. Ladies and gentlemen, you can trust yourselves. What you saw on that witness stand, that is real. A believable child is enough. Now, defense has harped on a lot of things. Defense is over here talking about this breast incident in locked door. We're right here. We're talking about whether or not Jeremy ROTHENAY touched Angie's vagina on the night of July 28, 2018. And the answer is he did. When you guys took that oath, you're smart as a jury, you said one credible witness that I believe beyond a reasonable doubt. That is enough. Angie and her mom, they're not paid actors. We didn't fly them in from Hollywood. Let me ask you, is it reasonable to think that a 14-year-old girl who was 11 at the time would wait 4 years, come in here with absolutely no motive, tell 14 strangers about the most uncomfortable moment in her life, subject herself to that? If it wasn't true, why would she do that? That is not reasonable. She's waited a very long time for justice in this case. What does she have to gain? Don't you think she'd rather be at home, playing with her dogs or at school? Why would she come in here and be re-victimized? What you guys saw on the stand, that is credibility. When you have nothing to gain by waiting 4 years, you come into this courtroom because you want nothing more than to let someone know that what they did to you was wrong and they need to take responsibility. Now let's talk about this. It has been 4 years. Think about what the world was like 4 years ago. Think about all that's happened in this child's life, in Christina's life, in y'all's life. Defense has tried to say she's inconsistent. No, she is not inconsistent. She said he touched my vagina. He rubbed my vagina. That has been consistent the whole time. We're not here about any other incidents. And Eric Mata said sometimes kids don't outcry about everything all at once. Christina told you she doesn't remember a locked door. That's what she said. But you know what? She told you she trusted Jeremy at the time. And she obviously did because she left her 3 kids alone with him. She trusted him, so if you walk up to a door and it's locked, you might not think much about it. She didn't say her daughter's a liar. She 100% believes her daughter. You can tell that, and you guys know that from watching that on the stand. And you heard her voice crack when she read those text messages. And I want you guys to go back there and read those text messages of a terrified little girl and what she went through that night. Mom, please help me. Mom, don't call him. Think about that. It doesn't matter that Angie doesn't remember exactly the order of who she told or these minor details. She's consistent with what happened that night. He touched my vagina. He rubbed my vagina. This was not an accident. She told you about the position of her leg. She told you how she was sitting, the tablet. She told you what she was wearing. Those are sensory details. You don't make that up. The defense is harped on Elijah. This case is not about Elijah, her younger brother, who the testimony came out, didn't know what went on.
Judge, I'm going to object. That's not what the testimony was. So she's actually misstating the evidence.
All right, ladies and gentlemen, the jury, you will remember the testimony as you heard it.
You have the testimony in this case. You heard from Angie. You heard from Christina. You saw the text messages. You heard Christina talk about how when she got home, Angie's curled up in a corner of the room crying. You heard from Detective Stokel about his investigation, and you heard from Eric Mata. And they all seem like credible witnesses. And if you don't like something about their investigation or what they did, don't hold it against Angie. This case is about Angie. A believable child is enough. And if a defendant isn't dumb enough to videotape what he's doing in his own home, a believable child has to be enough. We've proven to you beyond a reasonable doubt that on July 28, 2018, this defendant intentionally and knowingly had sexual contact with Angelina Straub by touching her vagina with the intent to arouse or gratify the sexual desire of any person, and she's under the age of 17. She's always been consistent about that. Defense of these cases terrify him. Well, you know what? These cases terrify me too. That someone can do this to a child, do this behind closed doors, and think they can get away with it. Because they can just come in here and say, oh, don't believe her. Or, oh, she said this one thing, so don't believe her. Let me ask you, how would we ever prosecute people that do these sorts of things to child? Let Angie know you believe her. Let her know that a believable child is enough. Let her know that coming in here wasn't in vain. That sitting up here subjecting herself to that wasn't in vain. That waiting 4 years for justice wasn't in vain. Find him guilty.
All right, ladies and gentlemen, the jury, we've received all of the evidence in this case. Now, as I've been telling you before, don't deliberate until I instruct you. So once you go to the back and choose your presiding jury, you may begin deliberation. And I could have the two alternates remain here, and that will be Tony Vincenzio and Alexa Rodriguez. If you all could remain, please. And everyone, please rise for the jury. Oh, yeah, you will be seated. Yeah. All right, everyone else, please be seated.
Just want to run across the hall. I had a client actually.
No problem. All right, and we're gonna stop video. right.
This particular day that I just got arrested last Friday, got real drunk, so this was in the back of my head. And, he's funny as fuck. I took a piss on the cop car. Yeah, the SAT. Downtown.
Hello, everyone. Good afternoon.
How you
All right,
doing?
Attorneys, and I see Mr. McCrum, you've already done that. So attorneys, if you could add the name of your client and whether or not it's criminal trial division or family violence, that would help us move faster.
Thanks,
Yeah.
Criminal trial.
All right, and then Regina Scribner Tibbs, who is your client?
Yes, my client is Caleb Lee Coleman. Coleman Lee.
Criminal trial division or family violence?
It is criminal. It's not family violence.
Galaxy A75G, the person with the hat on, you're in the courtroom, you need to take that cap off. And what is your name, sir? You're on mute.
Excuse me, Derek Williams.
Yes, what is your name?
Derek Williams. I'll go outside because I'm at work.
All right. So, Mr. McCrum, I'm going to send you to breakout room number 2.
Thank you.
You're welcome. Miguel Hernandez, I'm sending you to breakout room number 3.
Thank you, Your Honor.
You're welcome. Regina Tibbs, I'm sending you to number 4.
Thank you, Judge.
You're welcome. Carl Alexander, I'm going to send you to number 5.
Judge.
Michael Sawyer, who is your client?
It would be LaQuinn Heisen, Your Honor.
Is it criminal trial division or family violence?
This would be criminal trial, Your Honor.
Okay.
It's my good day. I've seen you twice today.
Yes, me too. How's your brother doing?
I'm hoping if he comes in tomorrow, no doubt we'll go to your courtroom. He's going to be here. He may have a federal matter here tomorrow.
All right, thank you. I'm going to send you to number 6.
I told him last time we were in court, he should have waited.
He should have. All right, Linda Corley, I see you still connecting to audio. All right, everyone, today is Thursday, so just be patient. Your attorneys are zooming in and they'll get a chance to confer. No one is excused unless I excuse you. To all the inmates who are at the jail, you're not allowed to use the chat box or the internet. If you do any of those things, you'll be sent back and we will see you into anywhere from 60 to 90 days. Mr. Young, is it criminal trial division or family violence?
I believe it's criminal trial, Your Honor, although it might cross over because it's apparently a former stepfather is the alleged victim.
Okay. I'm going to send you to breakout room number 7.
Thank you.
Judge, I was having problems with my audio, but I can hear now.
Okay, no problem. Who's your client?
Samuel Real. And I've been working with Marcus. I just recently talked to him, I think yesterday, so I could probably give you an update as soon as you're ready.
All right, just give me a moment. Just 1 second while I place other people in breakout rooms. Martin Guerra, I'm going to send you to number 8. Raymundo Alamon. Raymundo Alamon. To all of the attorneys who are logging in now, if you could please add to your name the name of your client and whether or not it is criminal trial division or family violence, that will make everything go much quicker. All right, Matthew Allen, who do you have?
Hi, Judge. I have Nicholas Cornelius. It's a CTD case.
All right, I'm going to send you to number 9.
Thank you.
John Simpson, I'm going to send you to number 10.
Thank you, Judge.
Laura Lefton, I'm going to send you to number 11.
Thank you, Judge.
Albert Flores, I'm going to send you to number 12. All right, Ben Stevenson, are you changing your name?
I'm not sure how, and I don't want to log out because I might not get back in. My client is both family violence and criminal trial division, but I've been working with Michael Villarreal most recently.
Just 1 second.
Thank you so much.
You're welcome. I'm going to send you to number 13.
Thank you.
You're welcome. Russell Mitchell, who do you have?
Judge, I've got Tammy Garrettson. I apologize. I'm an old man. I don't know how to add things. I need my wife to help me do most of my Zoom stuff. So it's a criminal trial division case.
You say Tammy, what's the last name?
Garrettson. I can't remember who I've been dealing with. There's one prosecutor. I don't know if it was Joe Ray or I'm not sure who I dealt with last
I'm
time.
going to send you to number 14.
Okay, thanks, Judge.
You're welcome. William Davidson, I'm going to send you to number 15.
Thank you.
Larry Blomquist, who do you have?
I have Daniel Zamaripa, family violence.
How do you spell the last name?
Zamaripa is ZAMARRIPA.
All right, I'm going to send you to breakout room number 16.
Thank you.
Kelly McGinnis, I'm going to send you to 17. Joseph Acevedo, who you have?
Jason Whitley?
Criminal Trial Division or Family Violence?
Yes. Criminal Trial Division. Criminal Trial Division.
No, I heard you. I'm gonna send you
Okay.
number 18.
Thank you.
You're welcome. Eduardo Jimenez.
Yes, Judge, I have two clients, I believe, on your docket. One is Fabian Vega, and that is Criminal Trial Division. And then the other one is Michael Rivera, and I believe that's Family Violence.
All right, it's taking me longer because I'm dealing with the laptop. I'm
Sure.
gonna send you number 19.
Okay, was that for Fabian or is that for Michael or both?
I'm sending you there for both.
Okay, thank you, Judge.
You're welcome. Brendan Lopez. Brandon Lopez.
Yes, Judge.
Yes, who do you have?
Eugene McBee, criminal trial.
I'm sorry, what's the first name?
Eugene.
I'm going to send you to breakout room number 20.
Thank you, Judge.
You're welcome. Valerie Hutland, I'm sending you to breakout room number 21. And Linda Corley, I'm going to get with you. Albert Charles, who do you have?
Your Honor, it's D'Angelo Robinson. I got a notice that we had court in April, but I got this notice as well, and we had court on Monday.
All right, is it criminal trial division or family violence?
He has one in each, or at least one in each.
All right, Caleb Spohn, are you in a bunker? What's going on? I'm going to send you to breakout room number 22. Mr. Charles, I'm going to send you to 22.
Thank you, Your Honor.
Albert Acevedo, who do you have? I'm sorry, Ernest Acevedo. Your name is spelled different.
Yeah, I'm on my phone, Judge. I've tried to fix that. I have Jonathan Cruz Garcia and Fernando Toro. Fernando Toro is supposed to be a dismissal for pretrial diversion, I believe. That's family violence. Jonathan Cruz right now is a trial case. Probably will stay that way, but I'd like to confer. My practical problem is Comal County. I'm waiting for a motion to suppress to start in County Court 1 in Comal. And so if I have to log off, if I get called in, I have to log off.
Okay, is it criminal trial division or family violence?
The trial case is CTD. Fernando Toro is family violence. But I think they're supposed to turn into dismissal because he's on PTD.
I'm going to send you to breakout room number 23.
Right, thank you.
You're welcome.
And if I log off, Judge, it's just because I'm in a hearing.
All right, I understand.
Thank you.
Judy Whitmer, I'm going to send you to breakout room number 24. All right, Linda Corley.
Hi, Judge. On my case, I've been working with Marcus Sanders and the misdemeanor prosecutor, Brett Boses. I believe that we have, we're at the point where we can go forward with a plea on the misdemeanor. I think I saw Marcus, I'd sent him a chat. Maybe he could also jump in here. It's my understanding that we're going to be pleading out to one of the misdemeanors and all the other cases will be dismissed.
And that's on Mr. Raleigh?
Yes, Your Honor.
All right, how many, I only have him as one felony case. Is there more than one?
No, he just has the one felony, Judge, and the rest are misdemeanors.
All right, where's your client, Mr. Rao?
He is listed as iPhone. He is, can you wave, Mr. Rao, or unmute yourself and say hello? Can you unmute yourself? He's not real great with technology, but I think he has someone there helping him.
All right, is this your client? That's on the spotlight, an elderly gentleman with white hair?
Yes, with kind of.
Hello.
Hi,
Hello.
Mr. Rao, thank you.
Okay, Judge, I'm here.
All right. So have you talked to, which county court? Is this county court 2?
This is in county court 2. Yes, I've been working with both Marcus Sanders and also Brett Boses in that court.
So when is the plea going to be done in that court?
We have to ask for a setting. We just confirmed the amount of the restitution, Judge. We've just received that. And so now we need to just get a setting in that court. I've got to request it. He's set out for quite a while, but we're going to be asking for a plea setting. I don't suppose Marcus, I thought I saw Marcus, but maybe he stepped away.
All right, so do you want to call county court at law number 2 to see what's the earliest date they can get you?
I can call, but usually he only responds to an email. So I'm sending an email and I'll also try to call them. Would you like me to do that right now?
Yes.
So I can get a hold of him? Okay.
And everyone just
could you put my client together with me?
All right. And Mr. Young, that's Mr. Rodriguez?
It is. It's in Moto G Power iPhone, and I'm going to court to breakout room number 7.
All right, Moto G, if you go to breakout room number 7, please.
Thank you, Your Honor.
And everyone just give me a moment.
We can go back on.
Martin Guerra.
Good afternoon, Your Honor.
Good afternoon.
Can I, if my client, Mr. Sturgeon, is available, may I go into a breakout room? He's in custody, Your Honor.
All right, I'm just finding your breakout. You are number 8. What is your client's full name?
Noel Sturgeon.
All right, he is not on the Zoom screen as yet. As soon as he is.
I'm right here. Sorry, ma'am. I'm right here.
How are you listed on the screen?
As 187 Noel 17K.
I think they don't have him listed as his full name. No. They just have him listed as Noel. All right, Mr. Guerra, you were in breakout room number 8. If you'll go back to 8, please. And Noel, if you'll go to 8, please. Matthew Allen.
All right, hi Judge, I conferred with Ryan. I don't have an offer yet. I did want to try to speak to my client. He should be on Nicholas Cornelius.
All right, do you have an offer or do you not have an offer?
I do not.
Is there a reason for that?
I believe Marcus was the one, I think Ryan was trying to get up to speed on it. And then I think Marcus is the one that's maybe taking the lead on that case.
Okay, I have that an offer was tendered on December 1st. So is this a new offer?
I was not the attorney on December 1st, so I don't know if an offer was.
All right, and when were you appointed? Let me see, March 24th. All right, does the state give you any idea when they would be prepared to tender an offer?
They didn't give me a specific idea, no. They said before the next setting, but I don't know when that would be.
Okay, just 1 second, let me find Mr. Sanders. Marcus Sanders?
Judge, I believe he's in a pretrial meeting, but he'll be done shortly.
All right, thank you. Just give us a moment then, Mr. Allen. I'll see you to a breakout room with your client, but I'll need you to come back to the main room after you finish speaking with him.
Okay, thank you, Judge.
Mr. Cornelius, if you'll go to number 9, please. Are there any other attorneys who completed conferring?
Your Honor, this is Sean Simpson, and I have.
Okay. All right, what is happening with your case?
Your Honor, Ryan is also trying to catch up to speed on this one. It was just handed to him. He did let me know that there's some discovery uploaded, and so I will let Jenny know that, and then I've got his contact information to where he can start conferring with her. She's setting up a CLE right now and asked me to step in.
All right. This case is listed as 2019. There has to have been another case. Was this the case that was re-indicted?
No, Your Honor, I think he was just recently brought into custody, is my understanding.
So you're saying it was at large case?
I believe so. And I think that he was in TDC for a little while and then was out, and then he was just recently rearrested.
Okay, just 1 second. All right, Ms. Ferguson, on Mr. Reno Corrales, can I have a 30-day reset, please? All right, we're going to come back on May 3rd.
May 3rd.
And Ms. Ferguson, that'll be for them for discovery and for the state to make an offer.
Thank you, Judge.
You're welcome.
They said I'll be back.
All right, Mr. Corrales, we'll bring you back on May 3rd. And if you don't have anything else with us, you are excused, Mr. Simpson.
Thank you, Judge.
All right, Norman, can you let them know that 4P Corrales can go back?
Judge, I've returned when you're ready for me.
All right, just give me 1 moment. All right, yes, on your client, Mr. Rao.
Yes, Judge. The Judge Uzamba is going to be out for a couple of weeks for conferences, but he did get me on for April the 29th.
And that's the earliest they can do?
Well, unfortunately, she's going to be gone for the next 2 weeks. There was one other date, but there's no way I can get it done on that date. And then that brought us to the 29th. Did Marcus join us by any chance?
No, he's in another meeting.
Okay. I will correspond with him and Brett through email.
All right, so we'll be back here on April 29th. The court will understand that you need to be in county court 2 first.
Okay, thank you, Judge. May my client and I be excused?
Yes.
Thank you, Judge. Mr. Ryle, you can go ahead and hit leave meeting.
Okay, thank you, Linda.
Judge, I'm sorry to interrupt.
Yes.
We're gonna have to bid it for May the 2nd.
Oh, they should have it done before then, Ms. Ferguson. I understand about that date.
Okay.
Thank you.
Should I put this on for the 187 for the 29th, Judge?
No, you can put it on the 29th, and if that case is already worked out before then, they'll give us the dismissal, which the court will sign. If it's not, then we'll see you back on the following day.
Okay, thank you, Judge.
You're welcome.
Judge, I have an update on my case.
Okay, thank you. And is your client in custody or on bond?
He's in custody, Judge, Mr. Watterson.
All right, what is happening with Watterson?
We have a plea agreement for judgment sat on a reduced charge and dismissal of the other pending indictment. I'm just waiting on paperwork to be emailed to me.
All right, thank you. And I'll send your client to the breakout room with you.
Thank you, Judge.
Mr. Watterson, I'm going to send you to a breakout room with your attorney.
Thank you.
You're welcome.
Yeah.
And let me see which room Mr. Alexander was in.
I'm in 5, Judge.
All right. You know what, Mr. Watterson, I'm going to send you to 2. That may make it easier for you to see the move pop up in on your screen.
Okay, do I just hit the join button?
Yes.
Thank you.
All right, Mr. Allen.
Oh, I'm back from meeting with my client. I'm just waiting on Mr. Sanders.
Okay, just give us a moment with that.
Thank you.
All right, Mr. Young.
Yes, ma'am. Okay, we've conferred. The prosecution has made an offer. My client has declined the offer. There's one other matter I want to bring up at the same time because she was in a triple rollover accident when she had a seizure and lost control of the vehicle.
Okay, who's your client?
It is Amethyst Garcia. She's on the screen as Moto G Power. She has bright red hair.
Yes.
She right now has a GPS monitor on. She's worried about that because she has 3 or 4 places in her spine that have been damaged. You can see she has a neck brace on. She's also had several broken ribs and some other injuries. One of her arms is bandaged rather thoroughly. She's on heavy medication and sleeps most of the time, basically. She's afraid she's going to not wake up when they call her about the GPS monitor. She's not really mobile at all. She can walk with a walker. I'm asking the court to consider removing the GPS monitor so that she won't have that issue.
All right. Are we going to trial on this case?
I believe we are, Your Honor.
All right, just give me one moment. One moment, everyone. I just need to sign some paperwork. All right, so on Miss Amethyst Garcia, you received all the discovery?
I've got the discovery on the assault case, Your Honor, and going through the file, I don't believe I have the discovery yet on the drug case.
All right, I have the drug case. It's the only case that's being indicted. I'm sorry, yes, the drug case is the only case that's been indicted. So you don't have the discovery on the drug case?
I don't think so. I don't know why, Your Honor, but I've got piles of discovery on the assault case, which is weird since, as you said, it hasn't been indicted yet.
All right, just give me one moment. And which prosecutor were you working with?
Miss Hayden.
Okay, just one second. Well, I mean for the drug case.
Say it again?
For the drug case.
She was the prosecutor I was dealing with, Your Honor.
Hayden is family violence. She's the one who was handling the drug case?
Yes, she was.
All right, State, is Miss Hayden and on the drug case as well?
Judge, I'm guessing she just handled the CTD case because of the family violence was, the leading case on it, but I could look into it.
You're saying that she's not receiving, that he hasn't received has not received the discovery on the drug case. I don't know how that's possible. It's indicted. So State, if you can check on that, and then Mr. Yeah, we're gonna put this to a jury trial.
Again?
I said, once you receive that discovery, we're gonna put it to jury trial. So just give us a moment. And Ms. Garcia, could you please put yourself on mute? The court does not need to see your medications.
Yes, sir.
All right, Mr. Young, if you can go back to your previous breakout room for me, please. And a prosecutor will meet you there from Criminal Trial Division.
Thank you, Your Honor. I believe it was 7.
Let me double check. Yes, number 7. All right, Scott McCrunch.
Yes, Judge. I conferred right now with Ryan Groomer. I believe we're here on a discovery compliance setting. There's a couple things that we're still trying to work out to get me in discovery. One is a phone dump that I've given them a flash drive and they have downloaded or are downloading, and I haven't picked it up yet. The other is, from what Ryan has just told me today, are more than one, I don't know if it's many or several, other uncharged cases that they believe are related. And so he has uploaded to Veripic, and I haven't seen those yet.
All right, but where are we on this case? Are we on the discovery on this case?
That is on this case, Judge. It's I assume these other cases they would try to use at either guilt, innocence, or punishment.
All right, but with regards to that other discovery from cases that is not this case, that is not the instant case, where are we at discovery on this case?
Just, I think, like I said, that flash drive of a phone dump that they downloaded today that I need to pick up.
All right, Ms. Ferguson. On Mr. Garcia, I need a 2-week reset date for discovery, and that's for discovery on this case. This case is an old case. If there's no discovery on the any other outstanding cases or that are not this case, of course, the court will consider whether or not that evidence should be admitted at trial. But this case is old. So Ms. Ferguson has us coming back on April 19th.
Very good, Judge.
All right.
Excused?
Yes,
Thank you.
you're welcome. Norma, you can let them know Carlos Garcia can come back. I mean, can go back 17K. All right, Matthew Allen.
I'm just waiting on the offer.
Marcus Sanders, let me see where he is.
Okay.
He's at number 20. What I'm going to do is I'm going to move you to number 21. Just give me a second.
Okay.
Where'd she go? All right, Albert Flores.
Yes, Your Honor.
Yes, I'll send you just one minute.
I'm done conferring, Judge.
Okay, just one moment. All right, Mr. Flores, you have Juan Garcia.
I've got two of them, yes, Judge. We're here on a compliance for Juan Garcia. The prosecution has told me that they just received the CPS recording and documents today. They're preparing the order for me to submit to the court, and that they will have that stuff available for me to pick up possibly this afternoon.
All right, this is Juan Antonio Garcia.
Yes, Your Honor.
How is your client listed on the Zoom screen?
He's the phone number 290-7228, black shirt, standing up.
All right, Norma, on Mr. Juan Garcia. Did you receive a offer on this, Mr. Flores?
I did, Your Honor. It was a while back, but yes.
All right, Mr. Ferguson, Ms. Ferguson, I'm sorry. On this case, can you give me a 3-week reset for a plea deadline? I'm sorry, 2-week reset for a plea deadline date, please? All right, we're going to come back on April 20th, Mr. Flores. And that will be your client's plea deadline date. The court will not accept any plea bargain agreements after that date.
Yes, ma'am. On that day, will we get a trial setting if we're not able to resolve?
Yes, you will have a trial setting on that date.
Okay. And I've also conferred on the second case, Judge. I just jumped on that about 2 weeks ago on Jose Raimundo Perez.
All right, and Mr. Garcia, you are excused. And how's your client listed on the Zoom screen?
He's wearing an olive shirt, Judge. It says iPhone de Raimundo.
All right, what is happening with this case?
Judge, I just jumped on it. I've received a good chunk of discovery, but I think that there's a little more that I need to go over. I'm asking for a little bit longer than normal recess. This is my first setting.
All right, and your client is Jose Raimundo Perez?
Yes, Your Honor.
All right, Ms. Ferguson, on this case, if I can have a 30-day reset and it'll just be a regular reset. All right, we're going to come back on May 5th. And you and your client are excused.
Thank you, Your Honor.
You're welcome. All right, everyone, just give me one moment while I check paperwork. All right, Mr. Sawyer.
Hi, Judge, I am back. I have spoken to Mr. Groomer. I have received a huge stack of discovery. It is most of the case, but we're lacking the prosecution guide, some key pieces, where I will make a request to get that information ASAP.
Okay,
However, based on our conversation, Your Honor, I think this case may go a different route than trial. I'll just say that right now.
okay, and why is there no prosecution guide?
Just don't know. Somehow just didn't make it in. It wasn't in his stack, wasn't in my stack.
All right, Ms. Ferguson or Mr. Heisen, can we recall this back in 2 weeks, please?
And if I go to a breakout room briefly with Mr. Hyson to kind of give him an update, Your Honor.
Yes.
Thank you so much. I took my coat off. It's getting hot in here. I apologize.
Oh, no, no problem. My mom always admires the way you're dressed.
Well, thank you.
All
Your
right,
mom, she has my vote, no doubt about it.
Okay. All right, I'm going to send you to a breakout room, but please make sure Mr. Heisen comes out of the breakout room, and your new setting date is going to be April 18th.
April 18th. Thank you, Judge.
Yes. So, Mr. Sawyer, I'm going to move you to number 7, and Mr. Heisen, if you go to 7, please. All right, Mr. Hernandez.
Good afternoon, Judge. Judge, I spoke to the prosecutor and to Mr. Brown. He informs me that he has retained Mr. Mauer, Robert Mauer. And so he, I don't know if Mr. Mauer has filed a notice of retained counsel yet.
No, nothing has been filed. Ms. Ferguson, can you call this for Monday, please?
I'm sorry, Judge, I couldn't hear you.
I said, Mr. Brown, can you recall this for Monday?
Yes, ma'am.
And it's just to see if an attorney, Mr. Bauer, has been retained. And so that will be April 4th.
Thank you, Your Honor.
All right, thank you. You're excused.
Thank you.
Thank you, Your
But you'll
Honor.
need to be, Mr. Hernandez, you'll need to be back on April 4th.
Yes, Your Honor.
All
Thank
right,
you.
thank you. And everyone just give me a moment. Have a great rest of your day, John. Oh, you still have amethyst. Just one moment.
Thank you, Your Honor.
Yeah, I was just gonna say bye.
I guess that could be another interpretation of the hand.
All right, Kelly McGinnis on John Pettis.
Judge, I spoke with Michelle and we've agreed on a date, if that would be okay with the court, of May 3rd. I'm trying to.
All right, Ms. Ferguson, what's a good jury trial date for Mr. John Pettis?
May 3rd is fine, Judge.
All right, then.
Perfect. And then I also have, Judge, one more person, and I don't know if Mr. Pettis is on the Zoom today or if we are waiting to bring
We
him.
do have him, but you have to stay here if you want to talk to him. He is
Okay.
held in the back.
Okay. Can I work on the other person I have first and then I can maybe hang on and talk to him?
Yes.
Okay, I have Derek Williams.
All right, so just 1 second, on Mr. Perez, have you received all the discovery?
I believe so, Judge.
Okay, in that case, the plea deadline dates have expired, Ms. McGinnis, so the court will only accept pleas that are open to the court.
Okay.
All right, and then you have Mr. Williams.
Yes.
And have you conferred with anyone on Mr. Williams or no?
I don't think so, Judge. I don't think, let me check and see if Charles had talked to anyone. I don't think there's a particular person that we need to talk to.
All right, I'm gonna send you to breakout room number 3.
Okay.
All right, Brandon Lopez.
Yes, Judge. I spoke with Mr. Marcus Sanders. He relayed an offer. There's a couple minor issues. My client has agreed to hire me on the 2 new cases. And right now we have Alma Benavides on those, so I need to get my notice and retained in ASAP. And then the offer that was relayed was not a complicated offer, but sort of an extensive. And so I'm asking the court for a little bit of time to file my notices and to explain to him the offer so that we can come back and hopefully.
Listed on the Zoom.
He's McBee, Eugene McBee. He is in a breakout room right now. I just came from there. I think room 20.
All right, let me see if I can get him back to the main session.
I can retrieve him if you like.
Yes, if you could, please.
Thank you.
Martin Guerra.
Your Honor, we went ahead and submitted the paperwork. We're just waiting for that, for the client to be sworn, and we're ready for the plea after that.
All right, is your client in a breakout room?
I'd asked him to come back to the main session, so I thought he was here.
All right, is this a motion to revoke our new case?
It's a new case, Your Honor.
All right, the court hasn't received all of the paperwork then. Has he signed all of the paperwork?
He said, yes, it sounded like it because he said that he saw a message saying you're all set. So,
all right, to the clerks, please go to breakout room number 1 with Mr. Guerra and his client.
Thank you, Judge.
Just 1 second, Mr. Young, I have not forgotten about you. All right, on Maccabee, Mr. Lopez.
Yes, Judge.
All right, Ms. Ferguson. On Clifton Maccabee. Can you set this for a contested hearing within 3 weeks, please?
Okay, we're no longer on mute.
I'm just waiting, Mr. Lopez, for the coordinator to give me a date.
Yes, Your Honor.
All right, we're going to come back on May 20th at 2 p.m. Your client need to appear in person in court.
Yes, Judge. And if we have an agreement by then, should I inform the court or just the prosecutor?
Maybe that's why we didn't go down there because.
Thank you, Judge.
All right, thank you. You're excused.
Thank you.
She's already.
Thank you.
In progress right now. So she wasn't going to start a new one.
All right, Ms. Wimbert, have you conferred?
Yes, ma'am, we have, and we have a reset date from Miss Norma of May 24th.
Where's your
I
client?
just wanted, he's right here in my office. I'll turn it.
All right, so Mr. Espinoza, what date is your jury trial date? May 24th.
May 24th.
All right, just give me a moment. Was this case re-indicted, Ms. Wimmer?
Yes, ma'am, it was.
All right, to the clerks. As I say all the time, on these cases that are re-indicted, could you please keep the original file because I will have no notes in this new file. So if you could make sure to grab the case on Mr. Rene Espinoza, please, and grab that file. Thank you.
I did it right now, Judge.
All right, we'll come back on the 24th.
Okay, may we be excused, Your Honor?
Yes, and you do have all the discovery?
Yes, ma'am, we do.
And was the offer rejected?
Yes, ma'am.
All right, then your client will need to be here on May 24th at 9 a.m.
Thank you, ma'am.
All right, thank you.
Thank you.
All right, and Mr. Young, I know it appears that I'm pushing you at the end of the line, but I'm just waiting for the prosecutors to come out. I appreciate your patience.
Always a pleasure, Your Honor.
But you know what? It takes someone with patience to grow magnolias. Are your magnolias going to bloom this year?
Yeah, I believe they will, but then I'm an eternal optimist. It's healthy. I've given it iron. I've done everything but hug the darn thing.
Well, I mean, you need to hug it. All
We've
right.
watered it with wine.
Okay. All right, Mr. Allen or Mr. Cornelius.
Yes, Judge. I do have an offer from Marcus. I would like a few weeks to be able to finish reviewing the discovery. There's multiple videos with surveillance, and then be able to talk to Mr. Cornelius about whether he wants to accept the offer or not.
All right, Ms. Ferguson, can I have a 3-week date for a plea deadline date? All right, April 20th is your plea deadline date. So he needs to make a decision after that.
Yes, Judge. And will we have a setting that day, or is it just we need to notify the court?
No, that's your court date.
Okay. All right. Thank you,
All right,
Judge.
everyone, just give me a moment. All right, that's the date that you'll need, your client will. All right, that's the date that you and your client will need to be back, April 20th, and that is your client's plea deadline date. Court will not accept any plea bargaining agreements after that date unless it's for good cause.
Yes, Your Honor.
All right, thank you. You and your client are excused.
Thank you, Judge.
You're welcome. All right, is there a prosecutor available on Amethyst Garcia?
Let's see. I was talking to Joe Ray.
Okay. All right, Joe Ray Garcia?
Yes, Your Honor.
Oh, no, that's a question for me to see if he's on the Zoom screen. You know, like Joe Ray Garcia, question mark. All right, on this one, Mr. Young, do you have all the discovery?
Your Honor, I do not. I have been assured by Joe Ray that it is available. My wife, as you know, is my technical support. She has requested it. If you can give us a plea deadline date, I will guarantee the court that I will have reviewed that because it'll be at the top of the stack.
All right. Ms. Ferguson, can I have a plea deadline date for 2 weeks on Ms. Garcia, please?
As long as it's not the 6th through the 8th of April.
Okay.
I have
Anything
a
after that?
I have an appointment in Lake Charles over those days.
Oh, well, you will get to see plenty of magnolias.
You think
And
so?
maybe the honeysuckle will be in bloom.
I doubt it. I think it's too early for them, even in Louisiana.
Not the honeysuckle, though.
Okay, honeysuckle is always there.
Yeah. All right. I'll see you on April 14th at 9. That's your plea deadline date.
Thank you, Your Honor.
Thank you.
And did you get that, Amethyst?
Yes, but were they going to do anything with the monitor part?
And I would like to readdress that, Your Honor. She is candidly, she's kind of punchy with the amount of medication she's on, and she's pretty disabled at this point. I don't think the GPS monitor is going to change whether she stays in bed or not.
All right. We'll just need the prosecutor to confer with you on that.
I mentioned to Joe Ray that I was going to be asking the court that. I don't think I got an answer one way or the other from him.
All right. Is there a prosecutor available to confer with Mr. Young on GPS matters for Amethyst Garcia?
Marcus,
All right, Mr. Young, I'm going to send you to breakout room number 5, and a prosecutor will meet you there.
Your Honor.
You're welcome. Larry Bloomquist.
Yes, Your Honor. So we've conferred, Your Honor, that the state has requested some records from CPS, and they've also requested some SANE records that they have not received yet. And I did do a counteroffer to the state today, but they need to get those records before they make a final determination. So we're just asking the court for a regular reset. We probably need to see those as well too, Jim.
Thank you. All right, can you make sure that these stay together? All right, thank you. All right, Ms. Ferguson, can I have a 20-day reset for Mr. Zamaripa for discovery?
And Judge, I'm sorry, did you say the 30-day?
No, 20-day.
20. Okay, give me 1 second, Judge.
Yeah, just put it roll bandage, put it.
Could you all make sure you're on mute, please? All right, we're going to come back on April 27th. And what your discovery, you said, is CPS records?
Yeah, Judge, there's CPS records and I believe the SANE records.
All right, we'll see you back on April 27th.
Okay, thank you, Judge.
You're welcome.
May we be excused?
Yes. Eduardo Jimenez.
Yes, Judge. So I had two, as you recall, Fabian Vega on the murder case. We had some new developments. Some witnesses have come forward, corroborating his story, and I turned that information over to Marcus, and he needs some time to review that material. And And then there's also some witnesses have come forward, not only from Fabian's side, but also one witness from the group that was that's on the victim side. So it's some important information, and it is a murder case. So I'd like to give Marcus enough time to look over that information and incorporate it into any maybe plea bargain that we might be able to work out.
All right, Ms. Ferguson, on Fabian Vega. Can I have a jury trial date, please?
I'm sorry, ma'am, I lost you. Can you repeat that again?
May I have a jury trial date on Fabian Vega, please?
Yes, ma'am. Can you give me 1 second so I can see the Excel file, Judge?
All right, thank you.
All right. Hey, Norma.
Excuse me, we're in the middle of a hearing.
Oh, I'm sorry, Judge.
Judge, can you give me just a second, Judge?
Yes.
Judge, if you'd like, I can continue with you on the other client.
Oh, no, just one moment. Let's get this taken care of.
Sure.
And then we'll take care of the next.
No problem.
Yes.
All right, Mr. Jimenez, on this case involving Mr. Vega, your plea deadline date and your jury trial date is going to be May 17th.
May
So
17th.
if an agreement is not worked out by May 17th, you'll be going to jury trial on May 17th. Mr.
Okay,
Vega
Judge.
will have you brought over, dressed for trial.
Right. I'll take care of that, Judge.
All right, thank you.
Very good.
Norma,
May we move on to
Elle,
Michael
30 can go
Rivera?
back.
I'm sorry, Judge, I didn't hear that last part.
I'm letting her know that Mr. Vega can go back.
Okay, thank you. And when you're ready, I can talk to you about Michael Rivera.
Yes.
Okay, so Michelle extended him a very generous offer, which is that he's going to have to plea out to a misdemeanor, and he's scheduled tomorrow to do that. And then they're going to drop the felony. So that's the story there. I just need to plea him out in the County Court 11 tomorrow morning, and then the rest will take care of itself.
All right, Mr. Norman, on Mr. Rivera, if we can put him down for Monday. And of course, if it's taken care of tomorrow, then we will be done.
Yes, Judge. Okay.
All right, so we'll see him back on April 4th.
Ma'am, you're gonna need to call me back because I'm super busy.
Everyone, please make sure you're on mute. All right, so April 4th.
Okay, Judge. Thank you. And may I be dismissed, Judge?
Yes. All right, Mr. Young, did you get a chance to confer with the state?
I conferred with Marcus, Your Honor. He is opposed to taking her off of GPS monitor. I don't know whether he's back or had to go to some other get together. There he is. My client has told me that she's concerned that she's not going to wake up when GPS calls her. And Marcus raised the question of whether they even do that. I don't know. That's what she's told me is her concern.
All right, she's listed as iPhone. How's she listed?
The Moto, I think they actually put her name on there, but it was originally Moto G powered.
All right, Miss Garcia, can you unmute?
Yes, ma'am.
All right, if you're not able to, if you don't wake up because you needed to call, that's not how GPS works.
No, ma'am. What I stated to him is that I've had to have my pretrial service officer call to like get me to charge the thing because I'm always asleep and medicated and stuff. And also I walk with a walker and stuff. So it's been hard to move around and stuff. And it's just extra stuff that I wasn't trying to have to worry about, hopefully. I mean, I'm always in bed mostly, so.
All right, well, Miss Garcia, there's a reason that I have you on GPS, and that reason still exists. So we're gonna come back on April 14th. If there's an issue with your GPS, the way this court handles any pretrial service violation is the court will contact your attorney and we'll find out what's going on if there's a violation, Mr. Young.
Okay, try really hard to keep that thing charged up, Amethyst.
Yes, sir.
Thank you, Your Honor. April 14th.
Yes, thank you.
Thank you, Your Honor.
All right, just 1 second. All right, and Mr. Sawyer, you're done with Mr. Heisen?
Your Honor, I am. Thank you.
Norma 17I, Mr. Heisen can go back.
And Your Honor, may I be excused?
Yes, you may. Have a great rest of your day.
Thank you.
All right, Russell Mitchell, your client, Tammy Garrettson.
Yeah, Judge, we have an agreement. We have a plea worked out. If I can just ask the court for a favor, I've got to get my wife to an appointment by 4 o'clock today because we're going out of town for a couple of days. Can we set this for a plea Wednesday, Thursday, or Friday for next week at the court's convenience? That'll give me time to get
the done on Monday.
We're going to be out of town. I'm going to be out of town Monday.
Yes.
I'm sorry, Judge.
Is there a reason it can't be done right now? It's not 4 o'clock.
Well, I have to go pick her up and then get going and be there by 4.
And what's the time frame on that?
Well, it's already like 3:15, and I think the district attorney, your prosecutor, still need to give me the paperwork and everything. So.
All right, it's 3:10. How much time do you need to go?
Well, I mean, I guess we can try to do it now, I guess, Judge. I just didn't want to.
Thank you. To the prosecutor, could you please get the paperwork for Mr. Mitchell?
Yes, Judge. Russell, can you send me your client's email in a chat, please? Norma will need it
Okay.
as well.
Okay, okay.
All right, and Mr. Mitchell, I'm gonna send you and your client to a breakout room.
I've already talked to her. I just got done the breakout room with her, Judge. I just need to get the paperwork and once we get the paperwork, we'll be ready to go.
All right, well, I'm sending you to, I'm sorry, not number 1, Miss Garrettson, because there's someone there. I'm gonna send you all to breakout room number 3.
Okay.
All right, Mr. Charis.
Yes, Your Honor. I talked with Mr. Groomer. The DA still has discovery they need to put together, and there is a case that is sealed that they're still looking at. So we do have a court date already of April 26th. If we could just reset, I mean, there's nothing we can do right at this time.
All right, so we'll see you back on April 26th then.
Thank you, Your Honor.
All right, thank you. You're excused. Norma Robinson, L17 can go back.
Hi, Judge. It's Lauren Lefton. If I could approach when you have a moment.
Sure. Have you been assigned to a breakout room or no?
Yes, ma'am. I already have.
All right, then just give us a moment. You're in line.
Thank you, ma'am.
Mr. Davidson?
Yes, Your Honor. We're ready on my case whenever the court's ready.
Well, as soon as the court receives the paperwork, I'll take that up.
Okay, thank you.
All right, Ms. Lefton?
Judge, I conferred with Ms. Sparks, my client Santiago Aguilar. He is present in the court, like via Zoom. They would like one more reset before they make their offer. We're kind of still conferring, so it's an agreed reset. If we could have one more pre-trial, that would be great.
All right, did they give you a reason why they haven't been able to tender an offer?
Yes, they are still trying to contact the victim in this case, and it was an accident, so they want some more time to try to do that.
All right, Ms. Ferguson, on Mr. Aguilar, can I have a 3-week reset, please? And everyone, just give me a moment while I sign paperwork. All right, we're going to come back on April 20th.
Yes, ma'am. May we be excused now?
Yes.
Thank you. Have a good day.
Thank you, you too.
Thank you, ma'am.
You're welcome.
I'm sorry, ma'am. May I leave?
Yes, you may leave.
Thank you, ma'am.
You're welcome.
Ms. Boyd.
All right, Bill Davidson, I'm just waiting for them to give me the paperwork.
Yes, Your Honor.
Ben Stevenson?
Yes, Your Honor. I had the opportunity to confer with Michelle Hayden. This case has been worked most recently by Michael Villarreal, and I'm told that Michael Villarreal is in trial right now. Actually, no, I'm told that he's on his honeymoon. I do apologize. Michelle says she's not familiar with the cases. I wanted to go ahead and proceed with the bond motions on these cases simply because he had bond and bond was taken away in 3 of his cases. I had filed motions and the court was prepared to hear those today, I understand, from Norma. She says, Michelle Hayden says, that she is not ready today.
So she is going to ask the court for a little more time to be ready on the motions. We would like to go ahead and have them heard sooner than later. It's up to the court.
All right, Ms. Ferguson? When is Mr. Villarreal back? I believe it's next week. Is that correct? All right. Are we able to put this on April 5th, Ms. Ferguson? Then what date, Ms. Ferguson? All right, we're going to come back on April 7th at 2 p.m. and we'll take up your matters, Mr. Stevenson.
All right, can I say something, Ms. Judge Boyd?
I advise against it, but it's up to him.
No, I'm just trying to tell her, like, I already been in here 40 days, what I'm saying? I'm not no flight risk, and then, what I'm saying? I'm still trying to make stuff shake while I'm in here, get back to my job and stuff like that. If it, what I'm saying? If you can work with me instead of resetting.
If you're trying to have things shake, my understanding, they don't have milkshakes at the jail. Number 14C can be excused. Mr. Stevenson will be back on April 7th at 2 p.m. and we'll hear your case.
I thank you very much, Your Honor. Have a good day.
Thank you, you too. All right, Mr. Davidson, the court is just waiting for documents in order to take up your matter.
I understand.
Thank you.
Thank you.
Ms. Hutton?
Hi, Your Honor. I have conferred with Ms. Hayden and I think we have all the discovery. I think today was our final discovery setting for Jaden Green.
All right, and do you have all the discovery?
Yes, but we are just talking about the family violence case right now. Brittany Sparks, or I believe Brittany, came in and spoke to me too, that they're putting their case kind of on the back burner until we deal with the family case.
All right, has an offer been tendered?
No, so I'm here to, well, Michelle, I don't know if you want to pronounce.
Yeah, Judge, we were just hoping to meet with the victim in this case before making an offer.
All right, Ms. Ferguson, can you recall this in 3 weeks for the state to tender an offer?
3 weeks, Judge?
Yes. All right, we'll come back on April 18th.
Thank you, Your Honor. May Jaden and I be excused?
Yes.
Thank you.
Okay.
Oh my
All
God.
right, are the parties ready on Noel Sturgeon?
Judge, this is Carolyn Welland. Is there possible, I'm late getting on. I wanted to see if I can go in a breakout room with a prosecutor before you start your plea or whatever you're going to do.
Who's your client?
Matthew Snow.
Is it criminal trial division or family violence?
It's I believe it's trial division.
Sending you number 25.
Okay, perfect. Thank you, Judge.
All right, who are the parties on Noel Sturgeon?
Jury for the state.
Martin Guerra, attorney for Noel Sturgeon.
All right, the court is calling 2021 CR 10856, State of Texas versus Noel Sturgeon. Can I have parties announced for the record for the state?
Joe Garcia.
For the defense?
Martin Guerra.
Are you Mr. Sturgeon?
You're talking to me, ma'am?
Yes.
Yes.
We're proceeding by video because of the pandemic. Any objection from the state?
And Your Honor.
Any objection from the defense?
No objections.
Mr. Sturgeon, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Sturgeon, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor.
I'm sorry, is that a yes?
Yes, Your Honor.
Mr. Sturgeon, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with a robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial? A right
Yes.
for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Mr. Sturgeon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
No, I do not.
No, ma'am.
Has anyone promised you anything other than the plea bargaining agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with
Oh,
what
no,
you
I have
represented?
I
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, your punishment is to assess 3 years in the prison. There's a $1,500 fine probated. State recommends community supervision. Taking into consideration 2020 CR 2673. There's no contact with Bethany, Betheney, Henderson.
Yes.
Celia, Celia, Sturgeon, Albert Salcedo, and Letitia Sarai. Do you understand that to be the plea bargain agreement?
Yes.
Defense is at the plea bargain agreement.
Yes, Your Honor. We did want to make a request regarding the no contact order.
All right. State is at the plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours of community service restitution in CATS 1 and CATS 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
It offers State's Exhibit 1 and its attachments.
Any
No
objection?
objection. No objections, Your Honor.
Mr. Sturgeon, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right, for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
Christina. I think it's
I'm hearing all the chatter outside the door. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Respectfully, Your Honor, we hope you follow the plea agreement. Also, with respect to the no contact order, one of the individuals listed is his sister. And they actually, at one point, used to reside together, and he may live with her again. So I'm hoping we could eliminate that as a condition of probation.
Well, wasn't his sister involved in this robbery?
She is a co-defendant, Your Honor.
It's sort of like, would you allow, if you knew beforehand, would you allow Bunny and Clyde to live together if they were placed on bond?
Well, with respect, Your Honor, they're definitely not Bonnie and Clyde.
No.
Oh,
So, I mean, it appears that they committed a robbery together. Well, I mean, it doesn't appear, I'm finding that they did. That's what's in the stipulated evidence. Where is
Yes,
your
ma'am.
mother in all of this, Mr. Sturgeon?
She's in Lubbock.
I'm sorry, what?
She's in Lubbock in a whole nother city.
All right, why are you and your sister here in San Antonio and your mom is in Lubbock?
We had family here for a while.
All right, and are you the older sibling or the younger sibling?
The oldest.
Why are you leading your sister astray then, committing a robbery?
I was taking care of her, but I was in jail in September and I lost my house.
About 10.
So that equals, I lost my house because I was in jail, and you're in jail for a reason, and therefore you commit a robbery. So did this robbery come before or after you were placed in jail?
It happened before.
Okay. And what's with that tattoo around your neck?
It's a rosary.
No, there's more than that happening with that rosary. Last time I checked, people don't have like 3, things hanging with Mary on it. So there's more than just Mary around your neck. So what's that around your neck?
It is a rosary and it's my last name.
You can't remember your last name?
No, I can't, ma'am.
So you don't know your last name?
No, I said I can't.
You cannot remember your last name. So
No.
that is for people to have identification in case they see you?
I guess so.
Then if people are supposed to know you by your last name, or you're using it, the tattoo for identification purposes, you probably should have your full name on there. All right, is there some kind of gang affiliation going on here? Does anyone know?
Your Honor, I never saw anything in the discovery materials that would indicate there was any gang affiliation, or I've never heard of any type of.
Going on, Mr. Sturgeon?
Yes, ma'am, what were you saying?
Is there gang affiliation in your life, in your background, in your past? Have you ever been a gang member? And when I say gang member, I'm not talking about the Boy Scouts of America.
Oh, man.
How do you support yourself?
I work carpentry.
When's the last time you did that?
And I was working with my dad a little bit before I got locked up.
So your father's here in San Antonio?
Yes.
Mr. Garrett, I'm having a hard time believing your client's story. Do you have any children?
No, ma'am.
How far did you go in school?
I went 4 years, but technically I was classified as a sophomore.
Why didn't you graduate?
I was gonna go back for my GED, but I never got the chance.
Why not?
I was working. I was working a lot. I work with my pops. He does carpentry. I work usually 9 to 5 every day.
All right, state, I see that you all did agree that there is to be no contact with Celia Sturgeon, but would you like to speak to that? He says it's his sister.
Yes, Judge, we would like to no contact. Furthermore, she is currently on community supervision for the same crime as co-defendant, and there's a no contact with him as part of the conditions.
All right, and I would have remembered your sister asking for that to be removed, so maybe you all shouldn't be together until you both get your life in order. And how old did you say you were?
I'm 21.
21? So you've started doing grown-up things, and grown-up things require that you get your own place to stay. So the court is going to sentence you to 5 years in prison, suspended and probated for 5 years, $1,500 fine, probated, no contact with Bethany Henderson, Albert Saucedo, Leticia Serrato, Celia Sturgeon, Cats 1 and Cats 2. Cats 1 and Cats 2 is supposed to be teaching you not to steal. You know, I can give that course in less than a minute. Don't take what doesn't belong to you. But it appears that you may need more than my one course, so you need to do Cats 1, Cats 2, 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring anyone to get a COVID vaccination, but if you do, 40 of those hours will be deducted. Employment within 30 days of release. There's to be no employment as a home healthcare provider with minors. GED or some type of certificate from a trade school or higher level of education. If you do those things, then the court will waive the remaining of your community service hours. However, if you don't, however, the court is requiring you to get your GED or either be in trade school or do something with your life that's productive, regardless. But if you are able to do those things, the remaining hours of your community service will be waived. I'm going to want field visits, random. We'll start out with 3 times per month. The UA hotline, regular Zoom reporting, or in person. Mr. Sturgeon, while you're on probation, you're not allowed to smoke marijuana. I know some people think, it's just marijuana, but while you're on probation, you're not allowed to smoke marijuana or drink alcohol. Do you understand?
Yes, ma'am.
And that's on top of not using any illegal substances. Ms. Reyes, is there anything else that Mr. Sturgeon needs?
No, ma'am.
Mr. Sturgeon, is there anything else that you need from the court in order to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you want to know the definition of a weapon or ammunition, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, and Mr. Guerra, if your client does well on probation, of course, the court will reconsider the no contact order. But for now, there's no contact.
Thank you, Judge.
All right, you're welcome. Mr. Davidson, you have Pacino Rodriguez, is that correct?
Yes, Your Honor.
All right, Mr. Noel, I'm going to send you to a breakout room in just a moment after we take up this plea. And Mr. Guerra, do you want to be in the breakout room with your client?
Yes, please.
All right, I'll send you in there first, but Mr. Guerra, please do not leave that breakout room until probation comes into that room.
Yes, ma'am.
All right, Mr. Noel, I'm going to send you to breakout room number 4.
Okay.
Court is calling 2021 CR 11552, State of Texas versus George Pacino Rodriguez. Can I have parties announced for the record for the state? For the state?
I can jump in, Judge. Joe
All
Garcia.
right, thank you.
William Davidson for the defense.
All right, and are you Mr. George Pacino Rodriguez?
Yes, ma'am. George Pacino Rodriguez here, ma'am.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Ms. Pacino Rodriguez, Mr. Pacino Rodriguez, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
I did, Your Honor.
Counsel, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
I did, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes,
State, it appears you're proceeding on the indictment as presented. Is that correct?
And Judge, this is Marcus Sanders for the state. Is it okay if I step in?
Yes.
Okay, we have an oral motion to amend the indictment. Specifically, the deadly weapon, we're moving to amend it from a firearm to a knife.
no objection, Your Honor.
Any objections, Mr. Davidson?
No, Your Honor.
All right, Mr. Rodriguez, do you understand that the state amendment is a substantive change to the indictment? And your attorney will be entitled to 10 days with that substantive change. Do you have any objections to proceeding, knowing that the change being made to the indictment is substantive?
No, Your Honor.
All right, Mr. Rodriguez, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Did you understand you're charged with aggravated robbery? That's a first degree felony. The range of punishment is anywhere from 5 to 99 years of life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, Your Honor, I do.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, Your Honor, I understand.
Did you understand you have a right to jury trial, all right, for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement?
No, ma'am, Your Honor.
Mr. Casino Rodriguez, did you intend to give up those rights and enter into a plea bargain agreement in this case?
No, ma'am, Your Honor.
Are you requesting a jury trial?
Oh, no, I'm not requesting a jury trial. No.
All right, well, please listen to my question. My question is, do you understand you have a right to jury trial?
Yes, ma'am.
Do you understand by entering this plea bargain agreement, you're giving up the right to a jury trial?
Yes, ma'am. Yes.
Did you intend to give up a right to a jury trial and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand you have a right for you or your attorney to cross-examine any witnesses the state will call and the right to remain silent?
Yes, ma'am, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand that the court were to grant your application for deferred adjudication and for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
yes,
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am, Your Honor, I have.
According to the plea bargain agreement, punishment is to be assessed at a cap of 12 years in the prison. The state opposes your application for deferred adjudication, and there's to be no contact with Adia, A-D-H-I-A, Niles Shurkumar, N-I-L-E-S-H-K-U-M-A-R. Did you understand that to be the plea bargaining agreement, Mr. Rodriguez?
Yes, ma'am, Your Honor, I understand.
Defense, is that the plea bargaining agreement?
Yes, it is, Your Honor. I just mentioned though, when I looked at that piece of paper that it wasn't checked off in front of the 12 cap, but I know that's what it is.
All right. State,
Yes, Judge, that's the agreement.
next I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, I have.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I have, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged in the amended indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
Yes, the state offers States Exhibit 1 and its attachments.
No objections.
Mr. Rodriguez, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am, I have.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Ms. Ferguson, if I could have a date for sentencing, please.
Give me 1 second, Judge.
All right, we're going to come back on April 26th at 9 a.m. And Mr. Rodriguez and Mr. Davidson, I'm going to send you to a breakout room. Probation, if you could go to breakout room now, and that would be breakout room number 4.
Your Honor, may I ask you a question?
Yes.
My client has told me that he's had some drug problems in the past, and so I don't know whether or not the court wants to order a TAP evaluation.
Yes, we'll order a TAP evaluation. Ms. Rebecca Reyes, if you could make sure that a TAP evaluation is done as well.
Yes, ma'am.
All right, thank you. And you all can go to number 4.
Thank you.
You're welcome. Oh, Norma, could you have somebody have Mr. Rodriguez go to number 4?
Yes, ma'am.
Thank you. All right, Ms. Scripps, Tips.
Yes, Judge, I had a chance to confer with the state on this. They are still waiting to talk to some witnesses, and I haven't received a discovery. So we wanted to, this is our first setting, so we're requesting a reset.
How's your client listed on the Zoom screen?
Caleb Coleman Lee. He's on a cell phone.
I don't see her on the Zoom screen. Is she listed?
Caleb's
another way?
iPhone.
It's a male. It's an iPhone, yes. Yeah, that's.
Hi, yes, ma'am, I'm here.
All right, Ms. Ferguson, can I have a 30-day reset on Coleman, please? All right, we'll come back on May 2nd.
Okay, thank you, Judge.
All right, thank you.
May we be excused?
Yes.
Thank you.
Thank you.
All right, Ms. McGinnis. All right, Mr. Acevedo.
Yes, Your Honor.
Yes. Yes, what is happening with your case?
Waiting for Joe Bray.
Oh, yes, Judge. Judge, on one of his cases, specifically the one ending in 10282, somewhere along the line, there was a mix-up with videos. It's for a different case that are uploaded on this case. So I need to figure out and find the correct videos that belong to that case.
Okay, and which case number is this?
This case number, ones where the wrong videos are uploaded, it's 10282.
All right, Ms. Ferguson, can I have a 3-week reset for discovery? Will that give you enough time, Mr. Garcia?
Yes, Judge, that should be good.
And Mr. Acevedo, I'll extend the plea deadline date. I
Thank
do
you.
note in the docketing sheet, it's mentioned that you had all the discovery, but I'm assuming no one knew they had the wrong discovery.
Right, as we were looking through it, it was like, whoa, it doesn't even come close. It's so far off. Thank you.
And that was-
You're
Yes.
welcome. So I'll see you back on April 18th.
Thank you. May we
You're
be
welcome.
excused?
Yes. Yes.
Judge, it's Carl when you have a moment.
Thank you. That's basically what it is. So basically what you're telling me is we're gonna be here till like midnight or something. Probably, yes, All right. Do you want me to go get you some pajamas from your house or anything? Okay, so that was the question. All right. Thanks.
Sky's blue. Yes.
All right, who was ready?
Judge, Mr. Washington's paperwork is all turned in, but he appears to have dropped off the Zoom. He is in custody, so if we can get a hold of the jail, get assistance with him. He's not the best with computers.
All right. Oh, he's in breakout room number 1.
Oh, I guess he's getting sworn in.
Yes, I'll see you to number 1 to make sure that's what's happening.
Thanks, Judge.
All right, Ms. McGinnis. You're on mute.
Okay, I can never find the cursor when I need it. I need to speak with Ryan Groomer again on Derek Williams, just briefly.
All right, Mr. Groomer.
And
then go to a breakout room with Ms. McGinnis. I'm going to put her in breakout room number 5.
Okay, and then Charles was under the impression that our other client, John Perez, wasn't going to be brought today, that you guys were just decided to bring him on Tuesday. Is that still, can that still happen or?
I'll let you speak with Miss Ferguson on that. Miss Ferguson, can you go to a breakout room with Miss McGinnis?
Do you want to just come with me to 5?
Yes, I will.
Okay, thanks.
Judge,
All right.
before I leave, can I just, Ed Bartolome is in impact court. He's in trial right now.
Okay, what is this for?
He has 2 clients that are set today, Judge.
Just give me a moment. I'll look on that. Just give me a moment, Miss Ferguson. All right, everyone, just give us a moment. All right, Carl Alexander. Carl Alexander going once.
Yes, Judge.
All right, who's the prosecutor on Waterston?
Go right ahead.
All right, the court is calling 2022 CR 0205, State of Texas versus Jeffrey Waterston. Can I have parties announced for the record for the state,
Joe Ray Garcia.
for the defense?
Carl Alexander for Jeffrey Waterston.
And are you Mr. Waterston?
Yes, ma'am, I am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Waterston, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am, I do. Thank you.
The court will find that the state is in, the court will find that the defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and you review it with your client?
To the best of my knowledge, Judge, the state has complied with 3914.
Court will find that the state is in compliance with discovery. Mr. Waterston, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor, I do.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are proceeding on the lesser included attempted unauthorized use of a motor vehicle, Your Honor.
Any objections?
No, Your Honor.
Mr. Waterston, I'm showing you what's entitled court's admonishment and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor, I do.
Did you understand the state is proceeding on the lesser included offense of attempted unauthorized use of a motor vehicle? That is a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
Did you understand? You're on mute.
Yes. Yes, Your Honor, I do.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am, I do.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Waterston, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you what's entitled plea bargain agreement page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of unauthorized use of a vehicle as a Class A misdemeanor. They're asking that your punishment be assessed at 168 days in the Bexar County Jail. There'll be a $0 fine. The state will take in consideration cause number 2022 CR 0705, and that this judgment will be satisfied. Did you understand that to be the plea bargain agreement, Mr. Waterston?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you were waiving your right to appeal? The only items that can be appealed are written pretrial motions that are filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not, Your Honor.
Then to the offense, the lesser included offense of attempted unauthorized use of a vehicle. How do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
State offer State Exhibit 1 and its attachments.
Any objections?
Judge, I've reviewed those with Mr. Waterston. We have no objections.
Mr. Waterston, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review this document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Follow the plea bargain.
All right, the court will follow your agreement. As previously stated, the court is finding you guilty of attempted unauthorized use of a vehicle, sentence you to 168 days in the Bexar County Jail, give you credit for any time served. Court will show that the judgment is satisfied. Take in consideration 2022 CR 0765. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
I'm sorry, the case to be taken in consideration is 2022 CR 0705. All right, next I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you, Mr. Waterson. We're off the record. How old are you, Mr. Waterson?
I'm 58 years old.
All right, you're in the same boat I'm in, and the fact that there's more of your life behind you than in front of you. So you're gonna have to start doing better. You understand?
Yes, Your Honor, I do.
All right, good luck to you.
Thank you very much.
You're welcome. All right, Mr. Alexander, you are excused.
Thank you, Judge. Have a great day.
All right, you too. Ms. McGinnis?
Yes, Judge, sorry, I did it again. Okay, so I have to remember what I did now. I spoke with Brittany. She said that Ryan had already logged off. So I think it's a first setting. We were trying to just get an offer. I'll confer with him outside of court. If we could just get one more pretrial setting.
All right, Ms. Ferguson, on Mr. Williams, can I have a 30-day reset, please? All right, we're gonna come back on May 3rd.
Okay, Judge.
Thank you. You and your client are excused.
Okay, thank you so much.
Excuse me, Judge, would that mean?
Yes,
Mr. Williams?
absolutely. Thank you.
Okay.
Yes, Mr. Navy?
Good afternoon, Judge. I apologize that I came back so late. It's been quite a day. But this was Ruben Coronado. We appeared early on your docket. We got it set for a trial date. But I think that it had been set, so there was set this afternoon, so there was no prosecutor present. You asked me to come back this afternoon to confer with somebody.
All right, and you were coming back because of what issue?
Just because we got it set for a trial date, but there was no prosecutor this morning because we logged in the morning when it was, I guess, set this afternoon. So I didn't confer with any prosecutor. We just set it for trial.
Yes, and I wanted to know if there was any changes in the fact that you wanted a trial, and if the state were making you a different offer or not. So who would be the prosecutor on Ruben Coronado?
Judge, I can talk to him. This is Brittany.
All right, so, and it's just to see if anything has changed, Mr. Navy.
Okay, sounds good,
And
Judge.
Mr. Navy, I'll send you to breakout room number 1.
Thank you.
All right, and Ms. Ferguson, who are the people who are here for Ed Bartholomew?
I'll put that in the chat, Judge.
Okay, thank you. Because I'm looking on page 9 and I don't see that. Brenda, do you see what page Ed Bartholomew's clients are on?
It's Perez
I just put him in the chat.
and more. Page 9? Yeah.
All right, George Moore. Your attorney is in a jury trial, Ms. Ferguson. Can we recall
Yes,
this
ma'am.
for next week, please?
Yes, ma'am. My attorney's not present.
All right, we're going to come back on April 7th. You're
April
excused.
7th?
Yes,
What time?
9 a.m.
Okay, thank you, ma'am.
Thank you. All right, Valentin Perez.
Yes, Your Honor.
Yes, your attorney's in jury trial. We're going to recall you April 7th at 9 a.m.
At 9 a.m.
Yes, thank you for your patience.
Thank you, Your Honor. May I leave?
Yes.
Thank you.
And to the clerks, you should have some plea paperwork coming back your way.
There's a cat on Zoom.
Where's what's her name? Tabitha. Oh, yeah. Yeah. All right, so since we have a short break, let me find the last. Yes, please.
Judge, I'll be right back.
And Judge, I send you a chat.
Raphael Leal. Carolyn Whitland.
I'm here,
Present, Your
Judge.
Honor.
Raphael Leal, I'm sending you to a breakout room to confer
Speaking.
with somebody from the state. Who's your client?
Colunga. Omar Colunga.
Criminal Trial Division of Family Violence. All right, everyone, I'm sending Mr. Leal to breakout room number 1. All right, Mr. Navy.
Yes, Judge. I conferred with Ms. Sparks and nothing's changed. We're just set for trial.
All right, thank you. You're excused.
Thank you, Judge. Bye.
All right, bye-bye. Carolyn Whitland.
Yes, Judge.
Yes, what is happening with your case?
I have conferred with Marcus. This was for discovery compliance and to get an offer, and he has tendered both. I believe we do have at least all the discovery that's in the state's possession at this time. And he did tender me an offer that I will communicate with my client. And I believe that we will probably have to do some additional discovery ourselves. And I do also want to get my client's medical records.
All right, Ms. Ferguson,
So
can you put a plea deadline date on this in 2 weeks, please? All right, April 20th is your plea deadline date. After that date, Mr. Snell, I'm going to give you your jury trial date.
Okay, perfect. Thank you, Judge.
Thank you.
May we
You
be
can find out
excused?
the- Yes.
All right, thank you.
All right. Can you put me on mute, please?
Okay, I'll put you in a breakout room again.
Did they like make one?
Oh, just a
decision?
second. Raphael Leal.
Present, George.
Yes, what is happening with your case?
Well, I talked to to Marcos and also talked to my client. And I believe Marcos still needs to talk to the alleged victim, Judge, in order to make us an offer. And I believe that's what we talked about last time, Judge. So I'm not sure what the holdup is.
All right.
Yeah, Judge, I'm asking for a short reset. It could just be a week. I want to have my investigator run some numbers. I left voicemails, and this was actually my first attempt myself to try to get in contact.
All right. Ms. Ferguson, can I have this recalled for next week, please? All right, we're going to come back on April 7th.
I assume, Judge, because I think I am in Gillespie County.
Yes, it's by Zoom.
Okay, I don't have any problem with that, Judge.
All right, thank you. Ms. Ferguson, can you let them know that Omar Kalunga can go back? And he's 17H.
You said April 7th, right, Judge?
Yes.
All right, thank you.
And Ms. Ferguson, on Jonathan Garcia, Mr. Acevedo said that he was in a motion to suppress out of county or doing motions out of county in person. Can we bring him back on April 7th as well? Or either on Monday? What date would you like to bring him back? All right, we're going to come back on April 7th, Mr. Garcia. Your attorney is in hearings out of county on motions. All right, and then Ms. Ferguson on Toro. Who's his attorney? It's Ernest Acevedo as well. Mr. Toro, we're going to call you back on April 7th as well. Your attorney is in another county in person.
Yes, ma'am.
And Norma, on that one is for a PTD update. And defense thought that that would be dismissed. I'm not sure on that. All right. So state defense, the deputy has told me that there's a verdict. And so we're going to bring everyone in. All right, thank you. Guys, just one second. everyone off the record for a moment, please. Deputy, just 1 second. Yeah, let me turn this on. Oh, yes, we're ready.
All right, so the jury.
All right, everyone, please be seated. We are back on the record in cause number 2019 CR 3013, State of Texas versus Jeremy ROTHENAY, sorry. Ladies and gentlemen, the jury, the deputy has informed the court that you have a verdict. Is that correct?
Yes, sir.
And is that verdict unanimous?
Yes.
All right, deputy, if you could pass me the verdict form. All right. And if the defendant could please rise. The verdict form reads, we the jury find the defendant Jeremy Ray ROTHENAY guilty of indecency with a child by sexual contact as charged in the indictment. You may have a seat. Is there anyone requesting that the jury be polled?
I do.
All right, ladies and gentlemen of the jury, what will happen now is I will point to you and I will need to know if this is your verdict or not. If this is your verdict, I need you to respond by saying yes. Does everyone understand?
Yes.
All right, and we'll start on this end. Is this your verdict?
Yes.
Is this your verdict?
Yes. Yes. Yes.
Yes.
Yes.
Yes.
Yes. Yes.
Yes.
Yes.
All right, ladies and gentlemen of the jury, thank you for your service. You are now excused and you're free to speak to whomever you wish to speak to about your experience and about the evidence. Does everyone understand? So you're, you may go to the back and Deputy, I'll be back there shortly. Thank you. Everyone, please rise for the jury. All right, everyone, please be seated. So, Mr. ROTHENAY, you can have a seat. So, the defendant is on bond. Is there a request from the state?
Yes, Judge, we asked that he would be remanded.
Right, defense?
Judge, he's appeared at every court date and asked the court maintain them on bond. If the court has any issues, we could keep them on GPS.
All right, is the defendant eligible for probation from the court or no?
I don't believe so. He's a convicted felon and she was under the age of 14.
It's in the statute.
No, I was wondering about his priors. That's why I asked.
Yes, she's correct.
All right. All right, then the defendant will be remanded without bond. Ms. Ferguson? If I could have in the chat box a date for sentencing, please. Is there something you need to read for me?
No.
Okay, thank you. All right, we're going to come back on May 3rd. Mr. ROTHENAY, the court will make a decision on your sentence on that date. I will base it upon whatever evidence that the court receives. Even though you're not eligible for probation, I'm going to ask for a report, a pre-sentence investigation, so that I can learn more about you. So Ms. Reyes, Mr. ROTHENAY, if I could have a report done.
PSI and TAP, or I'm sorry, just the PSI, ma'am?
Just the PSI.
Okay, thank you.
Judge, is that in person or Zoom?
If you want it in person, it can be in person or it can be by Zoom.
I'm okay either way, but 9 o'clock?
Does anyone anticipate on witnesses?
Judge, if we had a witnesses, it would be, I mean, I wouldn't think it would take that long.
I'll have witnesses, so but I guess let's do it in person.
All right, so that'll be 2 p.m. and Ms. Ferguson, that will be in person. All right, do you need to collect anything from Mr. ROTHENAY, Mr. Maurer?
Judge, I think he was gonna give me his property for the night.
All right.
So will you do that? Yeah. Yeah.
Yes. All right, and Ms. Reyes, I think we have one more plea agreement.
Okay.
And I believe, Deputy, could you send him the breakout room number 1, because I believe that Ms. Reyes will need to speak with him. And Ms. Reyes, we're going to send you to breakout room number 1 so you can collect whatever information you need from Mr. ROTHENAY.
Yes, ma'am, thank you.
You're welcome. Yes. Yes. All right. Both parties, it will be May 2nd. Mr. Bauer, it's going to be May 2nd. The clerk is saying May 2nd. Okay, all right, thank you.
Hello, sir. Can I get your physical address?
4102
Okay. All right. Russell Mitchell, thank you so much for staying around.
No worries, Judge. My time is your time.
Oh, that is so awesome. All right, where is
Hey,
your?
She should be on there. Oh, she's in the break. Well, no, she should be there. I told her to leave the breakout room.
All right, hello, Miss Garrettson. Thank you so much for your patience.
No problem. Thank you.
All right, I'm just having the court reporter set up. Should take like 2 minutes, and then we're gonna start. Okay?
Hey, and Judge,
Yes.
can I just tell you one thing on a personal note? I may be speaking for some other lawyers, but I appreciate the fact that you're continuing to do these type of dockets on Zoom. I appreciate it.
Oh, thank you so much. I'm a firm believer that there are some good things about Zoom.
Yeah.
And also, COVID is still out there.
That is for sure, my friend. That is for sure.
All right, the court is calling 2022 CR 091B, State of Texas versus Tammy Garrettson. Can I have the parties announced for the record for the state?
Marcus Sanders.
For the defense?
Russell Mitchell for Ms. Garrettson.
And are you Miss Garrettson?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Ms. Garrettson, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it? Ms. Garrettson? Did you review that document with your attorney? Did you understand it? And did you sign it?
The document, yes, Your Honor, I did, yes.
All right, did you review the document entitled Application for Deferred Adjudication or Community Service with your attorney, and did you sign it? Counsel, have you received all the discovery in this case, and did you review it with your client?
I did, and I have, Judge.
Court will find that the state is in compliance with discovery. The court will find that defendant has knowingly and voluntarily consented to enter a plea by video. Showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Judge.
Are you proceeding on the indictment as presented?
Yes, Judge.
Ms. Garrettson, what you're charged with is fraudulent use of possession of identifying information, 5 items or more. I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you electronically sign it at all appropriate places?
Yes.
Did you understand that charge is a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement or give you more than you bargained for, the fact that you entered into the plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
I'm sorry, what was that?
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, was it the intention of your client not to apply for deferred adjudication?
No.
We wanted to apply for deferred, Judge. I thought we applied for deferred and regular probation.
All right, state in the plea bargain paperwork, it states that there's no application for deferred adjudication.
Judge, the initial paperwork was done correctly. We signed and sent a corrected one that maybe the clerks didn't send.
All right, to the clerks, do you have the corrected paperwork?
It would be just the plea bargain sheet.
And it's a plea bargain sheet?
Yeah, it was an amended plea bargain sheet, Judge.
All right, thank you. All right, Ms. Garrettson, did you understand that if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is, and she was.
Ms. Garrettson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Off the record, to the clerks in the back, could I please have the correct plea paperwork?
Judge, I'm printing it out right now, Judge.
And just one moment, Mr. Mitchell, I'm waiting for the correct paperwork from the clerk.
Oh, that's okay. It's been that kind of afternoon, Judge. Don't worry.
All right, I'm going to show you what's entitled plea bargain page. Did you review that page with your attorney and did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. The state is requesting a $1,000 fine to be probated. State opposes your application for deferred adjudication of community supervision. State will take in consideration 2022 CR 0899B. There's to be restitution to Rafael Montalvo. All right, so it says here that the state recommends community supervision but opposes deferred adjudication. So state, are you opposing community supervision and deferred adjudication or just deferred adjudication?
Just defer, Judge, and I apologize. That's the best we could do with the electronic format.
No problem. So according to the plea bargain agreement, the state recommends community supervision. They're opposing your application for deferred adjudication. They will take in consideration 2022 CR 0899B, restitution to Rafael, RAFAEL Montalvo, and they're recommending community supervision but opposing deferred adjudication. And there's to be no contact with David Garcia. Did you understand that to be the plea bargain agreement? Ms. Garrettson, did you understand that to be the plea bargain agreement?
I didn't hear anything about those names and stuff.
Those are persons that they're saying that you may owe money to based upon this offense. So since you're charged with possession or fraudulent use of possession of identifying information, 5 items, it may be people that you don't personally know, but it's people that you're alleged to have had their identifying information. Do you understand?
Well, that David Garcia was my boyfriend.
I said that we're not to have any contact with him.
Okay.
So do you understand that to be the plea bargain agreement?
I guess I do now. Yes, Your Honor.
All right, defense, is that the plea bargain agreement?
It is, Judge.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm going to show you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes.
Do you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 3 years. There'll be a TAP evaluation, 150 hours of community service, restitution in cats 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, the state offers States Exhibit 1 and its attachments.
Any
No
objection?
objection, Judge.
Ms.
No objection,
Garrettson,
Judge.
I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it? In all the
Yes.
appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes.
Did you understand that today that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Ms. Ferguson, I need a sentencing date, please. And I'm going to request a TAP evaluation, Rebecca.
Yes, ma'am.
All right, we're going to come back on May 3rd.
Okay.
Ms. Garrettson, it's very important that you make all of your appointments. I'll base my decision on your application for deferred adjudication based upon a report that I receive and any other evidence that's presented to me. So we'll see you back on May 3rd at 9 a.m. And I'm going to allow you to speak with the probation officer and she'll give you further instructions.
Okay,
So
thank
everyone,
you.
we'll be back on Monday, Brenda, Monday at 9, right?
Yes.